The matter, my lord, it has only been made the representation. Unless the authority takes a decision on my transfer application, my lord, it will remain pending. That much.
Transfer in connection with?
School teacher. So they have made application, it is pending before the authority, a decision is to be taken.
Very well. Hand over the slips, please. But please ensure when you mention, please have a minute. Please ensure that the notices are served. Without the notice, no mentioning will be allowed. No. Without the notice, it shall not be taken up, sir. Sorry, sir. Please hand it back. So you serve notice and come back. I will take up these matters. That is the reason why you want to make it. When is the list? When is directed to be listed? When was it directed to be? It's in the Form A.
Your Lordship.
Final hearing, please wait. I shall consider after 2 days. Mention after 2 days. Let me first have a look as to the motions. Mention on Wednesday, sir. What is your urgency? Please mention with notice. Without notice, no mentioning will be allowed. Yes, excepting for these motions which are being handed over today.
New motion.
New motion যেগুলো আছে সেগুলো শুধু দাও। New motion না আমাদের সব motion হিসেবে
এটা শোনা যাচ্ছে না। Am I audible, Milord? Am I audible, Milord? Lordship, am I audible? Milord, am I audible, Milord? Milord, am I audible?
Blood, may I have a lordship slip to mention blood? List কল করে দেবো actually. লিস্ট কল করেছে?
Yes, sir. That is the manner. Okay. The conditions for taking IPC are mainly they have to be in position of the invoices. Where is that? Where do I get it? And of 16 to 8. 16 to 8. Notwithstanding, and maybe he is in position of tax invoice or maybe issued by the supplier registered such and such. He has received the goods or service or both. Have you stated in the petition that you are in custody of this? Where is your statement? No statement, sir. Mr. Mojindar, you are not paying attention while drafting the petition. Now, how can you succeed on the basis of this petition? Your genuine claim will suffer. If you have one.
Yes.
Anything else you want to add? Now nothing is there.
My lord, leave may be granted to file a supplementation.
You are showing me eligibility. You have to show that you are eligible, otherwise eligible in terms of the decision of ALD automobiles. Where is the decision of ALD automobiles? Can you hand over a decision of ALD automobiles? Anyone has it?
No, my lord.
You are doing revenue matters, sir. You have brought this decision. Anoni, ki mushkil. Where is it reported? ALD automobiles?
My lord, may I assist? My lord, the point in this case is that they have availed the ITC beyond the limit they prescribed in the Act. So kindly see this page 16. So the matter will be clear.
Page
16.
16.
Yes, my lord.
Yes.
May I read, my lord?
Yes.
Whereas on the basis of the return filed by you for the tax period March 2019, you have availed the ITC worth rupees 86 lakhs 05937. However, this inadmissible ITC as per the provision of 16(4) of the WBGST Act 2017 and CGST 2017, the return in form of GSTR 3B for the instant period was filed on 24/11/2019, my lord, which was beyond the stipulated period time period fixed on 2010-2019 to avail the benefit of ITC of such tax period. So, my lord, actually for the 1 year, 18-19, whatever the ITC they want to claim, it has to be claimed within the 2010-2019 as per the statute 16(4). So it is being held by the division bench also, because if you don't comply with the...
Where is it held by the division
Yes.
bench?
Yes. So they have claimed after the stipulated date.
Yes.
So that's why there is the addition. So my lord, 11, para 11. Once again, I
Yes,
read.
yes, please.
The Honorable Supreme Court in TVS Motors Company Limited, after taking the note of the decision in ADL Automotive, held that the ITC is a form of concession, my lord, which is provided by the Act. It cannot be claimed as a matter of right, my lord. This has to be better here. But only in terms of the provision of the statute. Therefore, the condition mentioned had to be fulfilled by the dealers. And in the Act 16(4), my lord, if my lord kindly see the 16(4).
Yes.
This is where the judgment of that Madurai bench comes.
Madurai is a single bench, my lord.
My lord,
This is a
persuasive
division
value.
bench, my lord.
No, the division bench does not say. Division bench does not say that you are not required to issue the form in GST. What is that?
GST 2.
My lord, GSTR 2 is our forms. It is doesn't have the any linkage with the, because if we read the section 41, the GST is the self-assessment tax. You have to self-assess and claim the tax.
Yes, my lord, that is where.
No, no,
That is
paragraph
the-
11 is paragraph 11 says that you have to comply with the terms, whatever is under the sun.
16(4), the terms is there.
My lord, that is
Section
where.
16(4), my lord, kindly see for the moment.
Where has it stated that if it is beyond the time, it cannot be given credit?
My lord, actually 16(4) is prescribed the time.
Yes,
So
my lord,
kindly see
yes.
the 16(4), my lord, once.
Constitutional validity of 16(4) has already been upheld.
Yes, my lord.
This ALD automobiles case, you have that.
My lord,
I
that has
will-
been already been challenged before Supreme.
Does not matter, sir. What has been held there, that is the law of the land.
Yes, madam.
And that is being followed. I need to follow this.
Yes, madam.
Till such time this is upset by the Honorable Supreme Court, I need to follow the
Yes.
law. So I want to see that ALD automobiles case is there.
Other two judgments has also reported in para 12 also, my lord. For the
No, where is ALD automobiles case? You have that. You should.
My lord, section 16(4) is more clear, my lord, but they will not entitle.
I want to.
So that's why
Is there any difficulty on your part in showing me the judgment?
no difficulty.
Then
my lord.
show me the judgment.
I will just get it, my lord. I will just get it. Give
Please show me the judgment once. ALD টা কোথায়? Which paragraph it has been referred first, then yes, ALD is 4. 2019-13 SCC.
Because
চালু আছে।
my lord, 11 and 12, the detailed discussion upon the 16(4), my lord.
Just a minute, let me go through this once.
And if we go through the.
Sir, you are wanting me to, you want me to decide this and dismiss this application?
No, my lord, actually, if it is on the merit, whatever the my lord decide.
No, you are praying for that.
Yes, my lord.
So if I have to be with you, I have to be convinced with your arguments.
My lord.
Issue number 3 and 4, sir, of this judgment. The use of the words shall in section 1911 does not admit any other interpretation except that the submission of input tax claim cannot be beyond the time prescribed. Section 1911 in fact gives additional time period for claim of input tax credit. The statutory scheme contemplates filing of timely returns before 20th of the succeeding month. Paragraph 40 of the judgment.
Well, this is where I want to come in.
You want to challenge this judgment also? You say this judgment is under challenge before the Honorable Supreme Court.
Well, this judgment is firstly it's of Tamil Nadu VAT Act. GS Tamil Nadu General Sales.
Yes,
Tax Act.
section 1911.
The section 1911 was for Tamil Nadu VAT Act. This is
Yes.
GST.
Does it have the same parameteria provisions here in section 16(4)?
My lord, 16(4) says, my lord,
Yes.
the person is entitled to eligible to take input tax credit in the matter of return. If they are filing the return within the prescribed period.
Proviso, read proviso.
My lord, may I read 16.4?
Yes, proviso, read proviso.
Yes, my lord. This is where the judgment of the Madurai bench comes in because the return was never issued.
Not necessary, because this is very clear.
My lord, the return as described by the statute in section 39
Yes,
for filing returns. This return was actually GSTR 3 when the statute was made. For claiming ITC, my lord, we had to file
yes,
GSTR
39,
3.
which subsection?
My lord, 39 subsection.
39 for prescribed manner within 13 days
Yes, my lord, the
after the
prescribed
end
manner
of
was-
such month.
It's only the due dates.
Yes, my lord. The prescribed manner was GSTR 3. It is not in the system, my lord. GSTR 3 never came into force.
My lord,
And this question also fell for consideration before the division bench. Come to paragraph 7. The imposition of penalty was well justified as the appellant had committed fraud by making a false and dishonest representation in GSTR 3B returns for the aforementioned period and claimed ineligible ITC and thereby reducing the tax liability. And then it goes down to record paragraph 8 and then 9.
My lord, the clause of section 39 was never discussed in this.
I am bound by the division bench.
my lord,
How can I ignore my division bench, sir?
My lord, because division bench says 16.4 is applicable and you have to
Not applicable. Say the rigors of 16.4 are applicable.
Yes, my lord. But
If the rigors of 16.4 are applicable, try and understand.
Yes,
Mr.
sir.
Majumdar. If the rigors, because I am finally hearing out your matter. That's why I am giving you the opportunity. If the rigors of 16.4 are available, Mr. Majumdar, then the rigors inter alia include the rigors as provided in the proviso
yes,
to
my lord.
16.4.
Yes, my lord. For
If that is so, where does it say that GSTR 2 has to be issued?
My lord, it says return under section 39 has to be issued. That is GSTR 3
Yes,
and GSTR 3 never came into force.
never came into.
It never came into the system. After that, after this period,
No, GSTR 3 is by you.
yes, my lord, it is not there in the system. It is still not there. They have come up with a separate statement called GSTR 3B. And after, my lord, they have made that retrospectively effective on date by not in the section 39. They have given a retrospective effect that 3B to be a return from 1/8/2019. So on the date of March 2019, how will the assessee know that 3B will be a return? 3 was the return. It was never introduced. And they have come on 1st October 2019. They have retrospectively amended and said that no, 3B was a statement previously. And they have made that it is a return. GSTR 3 is a return, which is as per section 39, we had to file for claiming ITC. But it never came into the system. There was a statement called GSTR 3B, which they made a return retrospectively on 1st August 2019, saying that no, 3B is a return, 3 cannot be found, 3B is a return. It is the same thing for GSTR 2. GSTR 2 was a return for claiming the
So
ITC.
you accepted that position.
Which, my lord? 3B is a statement. My lord, we are accepting it. 3B is a statement, but return never came into force for that period, March 2019. My lord, if you can read section 39.
Yes. Yes.
My lord, if you can come down to this is substituted by Finance Act number 2, Act 2019, 23 of 2019, dated 1st August 2019.
Yes.
Previously, it was GSTR 3. They made a statement. It is never called a return. It was a statement GSTR 3B, which they made a return retrospectively on 1st August 2019.
But despite that, sir, how do you come under the ALD automobiles case that you show me?
Yes, my lord, I am accepting that 16.4 is valid on me. It's bound on us.
Yes.
But for applicable of 16.4, returns has to be there to claim it. GSTR 2 never came into force. GSTR 3 never came into force. They are saying that you have not filed a return.
Where have you said that in your petition? Where is the case made out by you in your petition? Sir, off the cuff argument should not be permitted, sir. You have challenged the ultra vires of this section once again here. Kindly see your prayers. Declare ultra vires. This issue has been concluded. Why will I permit you to re-argue this once again?
Look, we have not challenged the ultra vires. We didn't question one. Look, we have not challenged that.
What is page 52? Oh, that is not your prayer. Achha, page 52. Yes, page 52 you have challenged before the appellate authority.
Appellate authority, yeah.
Yes, my lord. We have challenged the people authority.
That is before the appellate authority.
Yes, my lord.
That was your parent challenge before the appellate authority. How can you enlarge your challenge now? What was your scope of challenge with the appellate authority? This is question of judicial review. See what was your challenge there. This matter should come to an end. If you have not challenged the other portions, you have simply said that this is ultra vires. Once this issue is decided in the ALD automobiles case, everything comes to an end.
Look, we have, after that, we have come to this in point number C of that prayer before the appeal. That is where they have challenged that 39(1)(3)B was not a return as per 61 rule 61 that.
Only this point remains. You answer me on this point.
My lord, only the simple question is that because they have filed the 3B. Once the GST was coming to the force, the government have designed some forms, but they are not becomes the operational. Now 3B at the very beginning, the government have made the operational 3B, and everybody is using 3B, and my petitioner is also using 3B. 3B, what they
When did he use the 3B?
yes, this page 16, my lord. 16, so cause notice. Whereas on basis of the return filed by you,
So-
for the text.
So he has filed 3B returns.
Yes, my lord, but it was not a return, it was a statement.
That doesn't make any sense.
That is the statute, my lord. Statute says return has to be filed. They are saying that 3B is not a return.
I can postpone the returns which was initially.
Yeah, I'm also trying to find, this is your only point, sir. I'm trying to
Fine.
find out from them what is your case on this.
My
Yes.
lord, actually, when the GST was implemented, there is the some returns, but while that returns forms are not made operational because that will cause the problems to the SSC.
So GST 3B was not made operational.
So yes, 3B is the one consolidated statement where the SSC can put their input tax and output tax and pay the liability. And as per the 16(4), the provision.
So on the basis of the return filed by him in GSTR 3B, he claimed input tax.
My lord, but there is a one restrictions that for the whole 1 year, if you have not availed the ITC, you can claim the ITC up to September. Like 18-19, you can claim the ITC by filing the return of the month September. But in this case, they have filed the returns.
No, he is asking for a direction that GSTR 3B as referred to in rule 61 of the GST rules is not a return as specified in section 39(1) of the Act.
Yes, my lord.
My
That
lord,
is
that
fine.
is because those returns are not, we are making operationals because the subsequent returns are made operational. By that returns, all SSC are happy and they are filing the returns.
This GSTR 3B has not been made
3B
operational.
is in the originally when the GST was implemented, the government has planned that these returns will be made operational. But subsequently, within 1 week, the government is noticed that if these returns are becomes operational, it will be cause a problem to the SSC. So for the simplify, the government come out with the one return.
What is that?
GSTR 3B. Where if he purchased the goods, whatever the ITC.
And he has also acted on that basis.
Correct, my lord.
My lord, that is
But
my.
yes,
Wait, sir, I'll give you a chance to
Sorry,
reply.
my lord.
my lord, only the small problem is that in this case that he has.
Sir, you are Mr. Sorry,
Dilip Kumar Agarwal.
Mr. Agarwal. Yes, Mr. Agarwal.
The problem is that in the GST Act, there is the due dates. If you miss the due dates, you will not get the ITC. The matter is dispute of matter in this case is that because in 3B that he has filed the return on 24/11/2019, but the due date was 20/10/2019. So far, it is specifically stated in the statute. Nobody can extend it. We are the creature of statute, we cannot. But my lord, it is the discretionary power. But what the
Discretionary power, the court has a discretion to extend it.
discretionary power means sometimes, but after the division bench, it is held that we have to strictly follow the conditions. Para 11 and 12, thoroughly it is being discussed. Well, if we can go through only for 11 and 12 once for the moment, the entire things will be clear. Para 11 and 12. Because in the Supreme Court also it is being said that therefore the fourth line, therefore the condition mentioned has to be fulfilled by the dealer. The condition in the 16th.
And the division bench says very recently, Honorable Division Bench of the High Court of Andhra Pradesh had
Yes,
considered
they have also said the same thing.
wherein a perimeter area provision under the Andhra Pradesh General Sales Tax 2017, namely 16(4) of the Act was considered in a challenge to the validity on the ground of violation of articles such and such.
In Govinda construction also, my lord, in the Bihar GST Act, the 16 was discussed. Again. Sir, we have received managed the ANDA automobile.
And one.
We
Yes, sir. Anything else?
Yes, my lord. This is where my lord, I want to come in. My lord, we are accepting the fact that we are bound by 16(4) as per the judgment or as per the statute. My humble submission is very small, my lord, where the 16(4) says that the return has to be filed on time. Whether the return came on time, the return was never offered. As per Rule 61,
Return you have to file.
yes, my lord, it was never in the system. Return was GSTR 3. On that date, on the date of action, the GSTR 3B was a statement. It was not a return. My lord, the petition is the other side has said that we have to read through the section as it is. It says the return has to be filed within time. The return never came into play. After that, it came into play. There was a statement called 3B. The return was not there. Rule 61, my lord, if you can come to Rule 61, where the return as per section 39 is described, it was originally 3, then it becomes 3B after the period in this is in question. The return has to be offered to us, then we will file. There was no such return. That is GSTR 3 as per Rule 61.
my lord, 3B is always there.
He is
From
having
the
only
same
one
section.
point. No, 3B was not there.
Yes,
3B was there, it
From
was a
the-
statement, it was not a return.
As a statement.
but you see, for the claiming, because we said that ki whatever you want to claim, as a, if you purchase something, if there is the ITC, you claim in 3B.
Well-
And whatever the, you have the sale, you show in 3B, because
Because
3B,
when according to you?
Final?
Yes, 3B became a return on 1st January 2021. My lord, Rule 61.
Rule 61 has been substituted by notification of 2021.
With effect from 1st January 21.
And in your case,
19, March 2019.
so in his case, sir, this 3B, GST 3B was not there.
my lord, the thing is that he is using 3B in the month of December and claiming the ITC. Right now, he cannot say.
Where is that 3B?
Yes, 16, page 16.
Page 16, it said, yes. But
Yes.
there was a statement.
No, my lord. No, whatever it is, a statement or because he is claiming the ITC on the basis of the 3B. He himself is filing.
Yes, man. We are,
So then,
my lord,
and
we are
everybody
filing a
is,
statement. We are not,
everybody is claiming on
we
that.
are not saying that we have not filed it.
But by filing a statement, you did ask for the return.
Yes, my lord, but as per 16(4), the statute, they can only disallow if we have not filed a return.
No, my lord.
That is the statute.
In that case, sir, you have not filed anything within that period.
Yes,
In
ma'am.
that case, you have not filed anything within that period. So then you don't have a chance to get the input tax credit at all for any.
That is where the 16(4) problem arises. The 16(4) says the return has to be there. They have not offered us a return. They have provided with us an alternative. My lord, the department
But-
cannot provide us an alternative to the statute. They are providing as
My
a
conscience, I was not with him, but my conscience is not permitting me
My lord,
on this ground. Yes.
16(4) once I like to read if permit. My lord, 16(4). Because you see the whatever the returns he is saying, but the act says 16(4) says that ki you have to
Very
claim.
well, sir. I will not dispose it of now. I will fix this Wednesday
witness
at 2:45 on.
115.
Heard the learned advocates appearing for the respective parties. Place this matter for further consideration on Wednesday, 12:45. Fixed at 12:45.
My lord, deeply obliged.
Because this is, my conscience is not permitting me to dismiss this application because that one point he has made out.
Lord,
Final hearing, sir, whichever way it goes.
My only submission is that we have to see the 16(4). But 16(4) was there in the GST Act from the inception. There is no change.
Any records you have?
16(4) is in
No,
the
any records you have? Any records?
records. We can call for.
Let the records of this case be produced when the matter is taken up next. বললে তাহলে তো সারাদিন চলে যাবে।
my lord, a small prayer, my lord.
Do not mention now. This is not the mentioning time.
No, it is. I'm not mentioning, my lord. My lord, as relating to this issue, my lord, 16(4).
Yes.
My lord, 16(4). There are many. My lord, there are many petitions filed on this issue, my lord.
You are appearing for?
The same item number 1.
My lord, my case is serial number 2, my lord. But
Which-
16(4), I was hearing your lordship, my lord.
Not-
Many petition has been filed as regards to 16(4), my lord.
Sir, it has not been called on. Yes, call to. Yes.
My lord, two prayers, my lord. Item number 2, I want to file a supplementary, my lord.
Why? What for?
My lord, some important, my lord, it is a matter of refund, my lord. Some
Left-
important point, my lord, what I,
No. You have to identify what points have been left out, sir. You can't become now wiser on the
my lord, at the time of,
party, sir.
my lord,
No.
at the time of,
Right.
at the time of disposing of the, my lord, I'll submit, my lord.
Matter fixed on
My lord, submit, my lord.
Wednesday. Same 12:45.
Well, briefly.
Yes. Next, call the next matter. Hmm.
Item number 3, my lord, I appear on behalf of the petitioner.
You are, sir, you are there, Mr. Agarwal. Item number 2, you are there.
No.
Who is appearing? You are.
I was the
Okay, GP नाम जावेद साहब नाम दिए दो. So you are there. हाँ जी, तो GP साहब नाम दिए दो बेटा.
Lord, this is my.
Mr. Chandra,
Churaria, my lord.
Mr. Churaria, your matter will be taken up after this. After I discuss this matter, then I'll take up your matter. I'll hear you also.
My lord, this is not 16.4. My lord, serial number 2 is not 16.4. My lord.
Then what is this?
My lord, this is a matter of refund, my lord, whereof my refund was disposed of, my lord, without allowing the refund, my lord, by the first authority, my lord. I went to an appeal, my lord. Thereafter, my lord, certain amount has been allowed, but certain amount has been disallowed. My lord,
Right.
against that, no document was given to me, my lord. That development I have not taken in my petition, my lord.
Very well.
My lord, that is why I want to file a supplementary, my lord.
Leave granted, leave as prayed for, leave granted to the petitioner. As prayed for, leave granted to the petitioner to file a supplementary affidavit. Let's a supplementary affidavit be filed within a period of 10 days from date with an advance copy thereof to the learned advocate representing the respondents. List this matter before the next circuit, available circuit.
My lord, grateful, my lord. My lord, as regards to 16.4, my lord, what I submitted was at least 50 to 100 petitions are pending before your lordship, my lord. My lord, in the principal bench as well as here, my lord. That is why, if your lordship fixes on Monday, my lord.
Sir, if it is a principal bench, it will be before me. I'll be taking up the matter.
Yes, definitely. But that is why I'm submitting, my lord, let it be fixed on Monday so that we come before your lordship, my lord. Before the circuit bench also, I have near about 10 matters, my lord.
Very well. Mr. Mojindar's matter on Monday. Mr. Agarwal, his matter on Monday.
Yes.
My lord, grateful, my lord. Grateful, lordship.
Monday, সোমবার দিয়ে দাও। ডেটটা করে দাও। If it is there before the principal bench, I'll be only taking up the matter. So there is no difficulty.
Definitely, my lord, I know it, but if your lordship passes an order here, my lord, it will be some problem will be over there, my lord.
I'll be, but that is why in his matter he had made up one point. Mr. Mojindar had made up a point. That is the reason why I want to reconsider that.
My lord, the present law
Convinced.
My lord, the present law as well as the previous law was totally different, my lord.
I'll consider, sir.
Yes, my lord. Grateful lordship.
12:45.
My lord, can I appear virtually on Monday?
You have difficulty?
No, my lord.
No difficulty, sir. I always stick up. এই ফাইলটা না আমাকে একটু দেখিয়ে দেবে।
My lord, item number 3, I appear on behalf of the petitioner. My lord, this is my affidavit of service.
Yes, what is the matter?
My lord, the point involved
Hey,
in.
what এটা 2 নম্বরটা নাও ফাইলটা। এটা কি? Oh, এটা 3 নম্বর। Yes. What is your matter, sir?
My lord, the point involved in this present.
Who is appearing for the respondents in this matter? Yes, you are there? Yes, who are the respondents?
State Council.
Yes, you are there.
Dimas Kakkar is appearing. Only.
What is the matter?
Not under the Jal Jeevan scheme, the land of the present petitioner was acquired by the concerned authority, wherein
Under the
by the concerned authority
Under
under the Jal Jeevan scheme.
Jal Jeevan scheme. Yes, what?
The land of the present petitioner was acquired by the concerned authority, and thereafter, my lord, no payment has been made to that effect till as of today. Wherein there is an admission on their part that my lord will find on page 75, my lord, of my application.
এই আমাকে একটা পোস্ট এগুলো দাও তো পোস্ট করে নেই এর মধ্যে পাতলা আর একটু মোটা দাও Yes, what instructions you have?
May I get for a very short password?
Very well, short password.
Yes.
Who is appearing for the petitioner in this matter? None appears for the parties. No accommodation has been paid for. Full stop. To provide one more opportunity to the parties to appear and present their case, comma, let this matter stand adjourned and appear under the same heading, Monday. Monday দেবো না Wednesday দিয়ে দেবো? Monday.
And for the state matter.
দেখি ভাই।
Lordship, I am for the petitioner.
Yes.
Lordship, I am praying for adjournment, Lordship. I am out of session, Lordship. Kindly fix it on Wednesday. I will appear before your Lordship personally and I will move this matter.
What is the matter, madam?
Lordship, it is a CPF and GPF, CPF to GPF matter and it is about interest for the delay payment.
Yes, you are for the state. What do you have to say to this?
My lord, secret orders vastly
Yes.
increase of interest.
Your copy of that order?
No, well, I do not have a copy of that order.
Yes,
Lordship,
madam.
Lordship, I have the copy of the order, but Lordship, kindly, as I am out of session, Lordship, kindly fix it on Wednesday. I'll produce before your Lordship all the orders.
Wednesday, as prayed for by the learned advocate representing the petitioner, list this matter for further consideration on Wednesday.
Yes.
Grateful, Lordship, grateful.
Lordship, I'm on behalf of the petitioner, Lordship. I'm praying for 1 day accommodation, Lordship.
Why?
Lordship, conducting counsel is not well, Lordship. He'll be coming tomorrow.
What is the
Lordship.
matter, madam?
Lordship, I'm not aware of the matter, Lordship.
No.
1 day accommodation.
File it out. Not today.
Great, Lordship.
Sir, you are there? Yes, fine. Yes, tomorrow come.
Lord, in 7, I appear for the petition. Lord, the affidavit of service.
Respondent?
Yes, you also.
Yes.
Lord, in this matter, 2 notices issued by the Municipal Corporation Jalpaiguri are under challenge, my lord.
Yes. What are the notices?
My lord, the notices, my lord, will find, one is at page 36.
Yes.
And my lord, the other is at page 65. I'll first apprise your lordship on 36, my lord. My lord, the page 36. My lord, the Municipal Corporation sought to invoke section 268 of the Act, which, my lord, deals with buildings ruinous and unfit for human habitation.
Yes.
Now, my lord, section 268 clearly states that before invoking the provision for demolition, notice has to be issued to the owner as well as the occupiers. My lord.
Show cause has been issued to you.
My lord, kindly sees the name. It says Hanuman Das Chachan, addressed to Mr. Hanuman Das Chachan. Now, my lord, this Hanuman Das Chachan is in no way related to the building concerned. My lord, will find that.
Who are you?
I am, my lord, the tenants, I am 10 tenants residing in that building. Lord, we have our place of business in that building, consolidated.
So you
We are
came to
10
learn
tenants.
with regard to this. Why didn't you now
No, my lord.
represent it?
But the notice was wrongly issued. I'll come to that. Kindly see page
So
35.
technicalities are not relevant. Show me generally how you aggrieved.
Yes, how is it?
My lord, I am aggrieved because I have specifically stated in my replies, in all the replies. Yes, my lord.
Municipal Act একটা দেখি। দাও এটা বের করো তুমি। Yes, বের করো এখান থেকে। Bengali Municipal Act বের করো না। Yes.
Corporation Act. my lord.
Yes.
Now, kindly see section 268.
Yes.
It shall serve upon the owner of the building and upon any person having an interest in the building, whether as lessee, mortgage, or otherwise, a notice to show cause within such time as may be specified in the notice as to why an order for demolition of the building should not be made. I mean, Lord, they cannot go around just selecting buildings and issuing notices. The notices have to comply with section 268. Now, my lord, I'll satisfy your lordship that this notice was wrongly issued. My lord will find that from page 35.
No, why, what wrongly issued? Sir, if you are a tenant,
Yes, my lord.
what is your right under
Why-
this? Where
why-
is the scope for you to be served with a notice?
My lord, it says owner as well as the occupier.
So
As
you
well
are
as
an
the
occupation
occupier.
of the building?
Yes, my lord.
Very well. After
For
the
50 years.
completion of the notice, what did you do?
My lord, we have addressed our replies and stated. Now, my lord, the replies are relevant because section 268(2) says that where
Did they take a final decision?
no, my lord. After that, another notice was issued, which is at page 65.
Yes.
That notice, my lord, was not addressed to me.
So let them decide this.
Yes.
Premature.
What I'm praying for is, what I'm
Yes.
praying for is an inspection of the building has to be conducted because it is the specific.
So
notice.
will I go into this at this stage? Nothing has
My lord,
been decided by them.
But my lord,
Only
page
that-
65. My lord.
I will not direct and find out the
Kindly, my lord, let me
procedure.
satisfy your lordship.
Yes,
Kindly see page 65 of
yes.
the application. It says whereas an on-site inspection has been conducted. My lord, this inspection was never conducted.
The inspection of.
Question of fact. How is the RIT could go into this? Whether this inspection has been conducted or not?
My lord,
And today no decision has been taken. Why will this RIT court interfere?
my lord, kindly orders a fresh inspection on the
No.
site
Why will I?
in the presence of all the
If you
occupiers and the
finally
owners.
aggrieved by the decision, then question comes, where is your reply?
My lord,
Where is your, I will only direct them to take into consideration your response and appreciate it out.
My lord,
Dispose it
my
out.
lord,
Where is your response?
my lord, all the replies are from my lord, page 38 to 64.
বই বের করো West Bengal Municipal Corporation Act.
Now, Lordship, may I point out the one?
না আনলে আনাও, নাহলে কি দেবে, আনলে। Yes, what do you have to say?
One thing, Lordship, if you Lordship, when you come to page number 36, it was addressed to Hanuman Das and any other owners, occupiers of the concerned building. Now,
Hey, why did you not, you were aware with the fact that they are in occupation?
no, we had listed this notice on the building.
Is he a recorded tenant?
Yes, my lord.
These are
Does his name appear in the assessment roll?
Lordship.
Does his name appear in the assessment roll?
Yes.
If his name appears in the assessment roll, was he entitled to a direct notice?
My lord,
Yes, Lordship.
certain.
Now, Lordship, kindly take notice of one fact, Lordship. Lordship, kindly. Now, they have given reply to this show cause notice. Now, this notice is regarding to the ruinous condition of a building. All they have stated that this building is.
Sir, why will I go into that?
Lordship.
Why will I go into that? If I have to go into this question, then only the writ petitions will be filed on the question of facts. Nothing will happen here.
And I'm perfectly agreeable to them deciding upon my replies, my lord.
Yes. The present writ application has been filed inter alia challenging the notices dated 28 December to 2023 and the notices dated 28 December 2023 and 29th of March 2024 issued issued under section 268 of the West Bengal
Municipal
Municipal Corporation Act 2006, hereinafter referred to as the said act. Full stop. ওনার নাম কি? Mr. Ghosh, learned advocate representing the petitioner. You are the one of the how many representing the petitioners?
10 petitioners.
না ওটা না, Mr. Ghosh পরে আসবে. It is a petitioner's case that the petitioners are recorded tenants in respect of premises number.
My lord, the premises number is 286/226. My lord, will find that at
Which paragraph? Which paragraph have you said?
My lord, the paragraph,
Which paragraph, sir?
my lord, perhaps it is not there in the petition, but my lord, the
Sorry,
holding,
I will not indicate that then.
holding receipt is in, is at page 35, my lord.
No, you tell me where is your rent receipt?
My lord, my rent receipt, my rent receipts are from, my lord, page 37 onwards.
So where is your from the rent receipt? Where will it appear that this is this same holding number?
My lord, the rent receipt does not specify the holding.
Then
It is merely a rent receipt with regard to the, my lord, the measurement of the premises. Because this is a whole building, this is a
no,
three-story building.
building number 1 হিন্দিতে লেখা আছে তো.
Holding number,
Page-
Lordship, 280.
Kindly read page 26, building number.
Holding number is 286/226/180.
Can you come to page 26,
Yes.
Can you read? Oh,
My lord, this is ward number 8. This is
ward number 8, then
ward number 8, holding number 226. It
are
only
recorded tenants in respect of holding number 226 in ward number 8.
ward number 1, my lord.
Oh, ward number 1,
One.
in ward number 1, in ward number 1. Full stop. By drawing attention, Mr. Ghosh, learned, Mr. Ghosh, by drawing attention of this court to the notice at page, to the notice at page 20, at page 36 of the writ application submits that although the petitioners are occupiers in respect of premises number 246, 268, 268 in ward number 1, no notice has been served on the petitioner, although proceedings have been purportedly initiated against, although proceedings have been initiated under section 268 of the said act. Sir, this is under ward number 8.
My lord, presently ward number 8. Presently ward number 8, my lord. Previously it was ward number 1.
Are you sure?
Ward number 8. It's ward number 8. Last one.
आगे ये चलो ना, आगे act चलो.
Has there been any change in ward number 1? Then I'll
No, ward number 8.
My lord, kindly notes down ward number 8.
your document is ward number 1. That does not give you legal right to maintain the writ application.
But my lord, these documents were issued back in the year 1974 onwards. Presently, it is ward number 8. The rent receipts are 20 years back, my lord.
Where is your current rent receipt?
My lord, current rent receipt, the last rent receipts were perhaps issued in the month, in the year 2014.
Where is that?
My lord, I'll come to it.
Where is the current rent receipt?
My lord,
Since
kindly
then,
see page 26.
since then, where are you depositing the money?
My lord, no eviction suit has been filed against me. I'm a statutory tenant at best. They have not issued any notice of eviction or any suit for eviction against me. I remain as a tenant in that property.
First of all, it is still further submitted that although it is still further submitted that despite the fact no inspection has been carried out at the petitioner's premises under holding at the petitioner's at premises number 266 at holding number 266
No, 226.
226 by the notice in writing dated 29th of March 2024, the municipal commissioner has claimed that the said holding, that the premises on the said holding is in a ruinous state. Such finding has been reached by the commissioner without taking note of the representations made by the petitioner. Full stop. By drawing attention of this court to the provisions of section 268 of the said act, it is submitted that before any order of demolition of any building is passed, by invoking the powers provided for in the said section, not only the owner but the occupier of such building is entitled to notice. Full stop. In this case, no notice having been served on the petitioners. In this case, no notice having been served on the petitioner. In this case, no notice having been served on the petitioners, the entire proceedings are without jurisdiction, and this honorable court may be pleased to set aside the same. And this honorable court may be pleased to quash the said notices. Mr. Dahl, learned advocate representing the municipality, on the other hand, submits that the steps have been taken by the respondents in accordance with law. Full stop. Notices due show cause in accordance with law. Full stop. The so cause notice under section 268 of the said act has been issued in the name of the recorded owner. Full stop. The rain receipts relied on by the petitioner would demonstrate that such rain receipts pertain to ward number 8, full stop. Full stop. In any event, since the petitioner should not be aggrieved. In any event, the petitioners okay, should not be aggrieved. In any event, the petitioners at this stage ought not to have approached this court, since no final decision has been taken. First paragraph. Heard the learned advocates appearing for the respective parties and considered the materials on record. Full stop. It is noticed that the municipal authorities had proceeded to issue a notice under section 268 of the said act. Full stop. From the documents disclosed by the petition, from the rain receipts disclosed by the petitioners, it does not appear that the petitioners are owners, are either owners or occupants. It does not appear that the petitioners are owners or occupiers, stroke tenants in respect of holding number 226 in ward number 1, in ward number 8. Full stop.
My lord,
in any event, without going into such question at this stage.
my lord, the rent receipt specified holding number 226.
What number is different, sir?
My lord, I am sorry.
In any event, without going into such question.
In Hindi, this is 8, my lord. I am sorry, my lord. This is 8. The symbol in Hindi is 8.
I do not know, sir. I am relying on
the symbol in Hindi is 8, my lord. In the rent receipts, my lord, it is 8, my lord, not 1.
It art.
I was mistaken, my lord.
It art. Huh? Acha, ठीक है. Yeah, so কি বল তালা গেল লাইনটা কেন ওই আগের লাইনটা কি ছিল ঠিক তার আগের লাইনটা full stop. No final decision has been taken by the municipal authorities. Full stop. It however appears that the petitioner has made representations before the municipal commissioner. Full stop. As such, I am of the view that the present writ application is premature. Premature. Full stop. Premature. Full stop. In any event, taking note of the submissions made by the petitioner. No, premature kotar line ke dilu. In any event, taking note of the grievance of the petitioner, I am of the view that justice will be served if the respondents are directed to consider the petitioner's representations and take a decision on the basis thereon. Consider the petitioner's representation and dispose of the proceedings under section 268 of the said act in accordance with law after giving an opportunity of hearing to the petitioners. Full stop. The entire process, entire decision with regard to disposal of the proceedings under section 268 of the said act must be taken within a period of 3 months from the date of communication of this order. Full stop. Full stop. Full stop. With the above observation and deductions, the writ application stands disposed of. Affidavit of service filed in court be taken on record.
Diploma.
Yes, next.
And for the purpose.
I'm praying for next week. I don't remember.
Why?
Conducting council is out of station due to
Any other?
it's of SMC regarding the land. This
Lordship, the dispute is that SMC has already issued final order of demolition and they have prayed for implementation of the order of demolition. They have prayed for implementation of the order of demolition.
Implement it.
Yes, now because why it was not implemented because of this election, no police persons were already once essentially tried taken steps to implement.
I'll direct you to implement it.
Lordship. Can you kindly give us because 26 is the vote, kindly gives us 1 week's time, we will implement that.
The present writ application has been filed any private respondent. Any private respondent?
Yes, my vote is for me.
Your Lordship, if needed, will not place this application. Then will not place this application
Why?
as per the instruction.
I will, despite that, I am going to pass an order. You do not place this application also.
No, what is nothing is sure, Your Lordship.
Yes. The present application has been filed inter alia praying for a direction upon the municipal authorities. To take steps in compliance with, to take steps in furtherance to compliance, no, to take steps in furtherance to, where is the order?
Your Lordship, the order, your Lordship will find that page number 29. This is the final notice. The private respondents did not appear for the hearing and ex parte order was passed because they did not have the building.
To take steps in compliance with,
The order dated, final notice dated 22nd January 2024.
in furtherance, to take steps in furtherance with the notice dated 22nd of January 2024. Full stop. Records reveal that, full stop, the petitioner alleges unauthorized construction had taken place
Second person, Pati Colony, ward number 3, road number 3, ward number 47.
at Pati Colony, road number 3 under ward number 47 within the jurisdiction of Jalpaiguri Municipal Corporation, which is adjacent to the petitioner's premises. Full stop. Previously, this court. No, full stop. On a previously instituted writ application which was registered as WPA 256 of 2024, this court, a coordinate bench of this court by its order dated 21st of February 2024, had directed the municipal authorities to submit a report in the form of an affidavit disclosing the steps taken by them on the basis of the complaint made by the petitioner. He said writ application pursuant to the aforesaid, the respondent pursuant to the aforesaid, the municipal authority. Now, the municipal commissioner had filed a report in the form of an affidavit. And in paragraph 8 thereof, ad inter alia, paragraph 8 and 9 thereof had inter alia stated as follows. Had stated that despite notice dated 13th February 2024, the 13th February 2024, Sri Soumitra Debnath had failed to comply with the same. Although since thereafter further steps were taken to cause demolition of the unauthorized structure by involving IC Pradhan Nagar police station, the said IC Pradhan Nagar police station, the same could not be complied with. The said demolition work could not be executed by reasons of the police employing by reasons of IC Pradhan Nagar police station, IC Pradhan Nagar police station employing a small number of police persons. Full stop. It is submitted that the same situation is still continuing, notwithstanding the aforesaid same situation is still continuing. Full stop. Mr. Dhar, learned advocate representing the municipality, submits that other steps have been taken by the municipality to enforce the order of demolition.
We will be enforcing the only kind that is that the police to cooperate. Last time there was a law and order situation. That way it was not be carried out. It was a law and order. We have stated in our affidavit.
Yes.
Now again we will go for a demolition. Again there will be a law and order situation. The police don't cooperate.
You will. Further steps are in the process of being taken by the municipality to enforce the final order, final notice of demolition. Final notice of demolition. Full stop. Police is a party.
Police is not a party.
So heard the learned advocates appearing for the respective parties and consider the materials on record. So taking note of the nature of allegations made in the petition, I direct that the IC Pradhan Nagar police station to be added as a party in the present petition. Mr. Saksad, learned advocate representing the state, accept service of notice on behalf of IC Pradhan Nagar police station. Full stop. Taking into consideration the fact that a final demolition notice has already been issued and such demolition notice has not been complied with by the illegal occupant, Soumitra Debnath. Soumitra Debnath is the illegal occupant.
Yes, he is the violator. Without a building permit, he not build the
Not being complied with Soumitra Debnath, the illegal occupant. I am of the view that where is the affidavit of service?
Your Lordship, I have not been instructed anything. I've just asked to take
illegal occupant. I am of the view that the final direction issued by the municipality should forthwith be carried out. Full stop. The IC Pradhan Nagar police station is directed to ensure adequate police assistance to the municipality for the purpose of carrying out the aforesaid process, to carry out the aforesaid demolition work. Full stop. Full stop. Let the aforesaid demolition work. The municipal authority is directed to file a report as regards the steps taken by the as regards the এটাকে বাঁচিয়ে রাখা দরকার আছে ওই উপরে থার্ড দি লার্নেড অ্যাডভোকেটস চলে গেছে পড়ো। এখানে একটা লাইন দিয়ে দেয়, it is well settled that illegal construction is a social evil. Full stop. Despite steps taken by the municipal authorities could not succeed in getting the illegal construction demolished. Full stop. তারপরে হয়ে গেল, ওটার পরে having regard to the aforesaid and taking note, ঠিক আছে? Full stop. The municipal authority, the municipal commissioner, let the process of demolition be completed within a period of how many weeks you require?
Your Lordship, kindly give us time till this 26th is the election. Before the election, Your Lordship, the model code of conduct, Your Lordship.
I'll place it after that.
Yes, Lordship.
Be completed within a period of 6 weeks. 6 weeks from the date of communication of this order.
Lordship.
Full stop. List this matter for further consideration in the next available circuit.
Lordship.
And dispose of holding. 6 weeks from the date of communication. Since nothing survives in the present writ application, the present writ application is disposed of. Directed to ensure, directed to ওই last line টা now কেটে দাও, ওটা is directed to
আমি তো responded.
take steps for carrying out the demolition proceedings in terms of its final notice dated
22nd January. 22nd January 2024.
13th of February 2024. না এটা কবে?
13th of February, this was order of demolition when the official was called for.
22nd January 2024. তারপরে 12 সপ্তাহের মধ্যে disposed of.
Demolition to be done within 6.
My lord, one indulgence, if possible, item number 3 could be taken up, Miss Martha, you said.
Item number 3, I am on behalf of the state, my lord. Now I
Take it.
received the brief, my lord. My lord, kindly the matter may be fixed on Monday, my lord.
What is the matter? Tell me.
I haven't. gone
Everything
through
will
the-
go to Monday.
But
It is
I have not gone through the brief, my lord. It's-
My lord, under the Jal Jeevan,
no order which will prejudice you would be passed without hearing you, madam. Let me understand. Thereafter, I'll give you time. Wait.
My lord, the double AG is representing the case, my lord. Additional Advocate General, my lord. He will be appearing in this case, my lord.
Very well. Let me understand from him what is the matter.
Your lordship, see.
Yes. Yes.
my lord, under the Jal Jeevan scheme, the land of the present petitioner was acquired by the concerned authorities, my lord.
মাঝমিটা জন্য পরে একটু সবে এগো মামলাটা এগোই নিয়ে এতগুলো আছে।
My lord, under the Jal Jeevan scheme of the central government, the land of the present petitioner was acquired. And after acquirement of the land, the payment in connection of the land with regard to the Khadiwari piped water supply scheme, the payment has not been made till date, my lord. And with regards to that, my lord, there is an admission on their part, which my lord will find on page 75. Page 75 of my application, my lord, where they have
The present writ application has been filed inter alia, praying for a direction upon the respondents to disburse compensation, to
My lord,
disburse.
my lord.
I'll give you time, madam. I've heard you. What are your answers?
My lord, I have to seek instruction, my lord, whether that payment has been made or not, my lord. The instruction.
Kindly hear what order I am passing.
Fine.
Kindly have the patience.
Fine.
কি বললাম? To disburse compensation in respect of the land acquired from the petitioner or petitioners. How many petitioners?
from the petitioner.
In respect of the land acquired from the petitioner under Jal Jeevan. Where is it? Under Khoribari pipe. Under Khoribari pipe water supply scheme. No. Under Jal Jeevan. Where is that language used? Where is that language used? Jal Jeevan? Under Jal Jeevan mission, concerning Khoribari Pipe Water Supply Scheme.
My lord,
Full stop. What is your name?
Mayank Roy.
Mr. Roy, learned advocate, by drawing attention of this court to the communication dated 2nd of January 2024, which is at page 75 of the writ application, submits that although the respondents have
Where it is admitted, my lord.
although the respondents had confirmed the factum of finalization and approval of rates in respect of the plots acquired from the petitioner, the compensation in respect thereof has not been disbursed. Full stop. Miss learned advocate representing the respondents prays for an accommodation to take appropriate steps, appropriate instructions in the matter.
Fine.
Having regard to the aforesaid, let this matter stand adjourned and appear
On Monday, my lord.
under the same heading, Monday.
I'm grateful, my lord. Grateful.
So why you say anxious, madam? Yes. Yes, call the list.
Yes, man. I'm appearing.
দেখি ফাইলটা দেখি দেখি কি মামলা দেখি কি সার্ভিস কেন করেনি Why? What is the matter? Since it is submitted on behalf of the petitioner that that service on the respondents is not complete, let this matter.
I'm appearing for all the respondents.
All the respondents completed. Service on the respondents is not complete. The petitioner prays for an accommodation. First up, Mr. Mr. Das, learned advocate, however, appears on behalf of the respondents. First up, at this stage, the petitioner seeks for an accommodation and prays that this matter may be placed before the next circuit. Having regard to the aforesaid, let this matter stand adjourned and appear before the next circuit. Next available circuit, na? Yes.
For this state.
Yes, who is appearing for the respondent? Mr. Das? So who is appearing?
Both are appearing.
Oh, very good.
He'll do the work.
No.
This is one transfer of the school teacher.
Yes.
She made application for transfer, but that was rejected on the ground of single subject teacher. And she's the only teacher of the school, she cannot take the transfer. However, people watch the interest into the issue. And you take to the Municipal Law Act with the scale, because there is something which has been laid down firmly that is going to watch it for once. But there is a need for transfers. There are various grounds which have been mentioned over there. Distance ground, length ground, several other grounds is there. Because of 2015, it is going on in the present. In 2021, the government thought of streamlining the whole process to the online portal. The online portal was logging with it. So through online, all the applications that happens. What the process is, one of the teacher will make application to the online portal with all the documents. It will go to the school. School will send it with the remarks to the AI of schools, district inspector of schools, or the consultation.
Yes.
Upon being satisfied with the same, the AI must send it to the respective Central School Service Commission for its recommendation. Upon being satisfied, the recommendation is made and the order, the transfer order is passed.
If they are not satisfied, rejected and sent back.
Send back.
Yes.
That is the whole process. Now, what happened? Subsequently, 2021. They temporarily suspended the online course. That's after my case. So I need to place the whole thing.
Why was it suspended? No, neither here nor there. You are not concerned.
I'm not concerned. So it was suspended temporarily and it was extended time and time after. And it was extended last after June 2024.
But your case does not fall within this.
No retrospective effect of it. So far the issue is concerned that single subject teacher cannot be given transfer has largely been tailed by the law of single education. And it has been allowed that no single subject teacher cannot be restricted on this ground and she or he has to be given transfer to the desired school.
What will happen to that school?
There is a procedure laid down.
What is the procedure?
There is an alternative teacher to count. Now the procedure is that.
Why are you asking for transfer?
The distance is the ground. which is a statutory ground upon which I can say. So
I could say that, show me.
I'm taking this place.
No, it's all right. What do you want now?
Now I'm showing 15 page for signing conflicts.
That I have understood. Show me the law.
Easy. That our kindly take it forward to come to the rules of page 39.
Yes.
Our kindly page 40. Group 3.
Yes.
Primary condition of general transfer to be so application of general transfer shall be entertained. Previously intends to get transfer to a school within the
Yes.
I've completed my service of 5 years. 13 years I have been rendering service to the school, and my distance is not more than 500 meters. There is a distance. However, the result is subsequent notifications and the amendments. However, kindly come to 37 forms, so you will give a clear idea of what is that. How the process runs in 37 forms.
No, how are you agree? What are you agree with? Correct. Now show me the law. The judgment, yes. No, not all. Say the High Court principal bench has already interfered. So covered by that. So why, yes, now.
I have other judgments. Of 13th of December 2022.
Yes. So that is the reason why you wanted Shumi through offline mode, as the portal is temporarily suspended. Yes.
Only if there is any alternative arrangement, mother. Then only it can be, because she was the
That
only
is
teacher.
inbuilt. That is inbuilt.
Yes. So kindly record that. Kindly record that.
Why record? Paragraph 8, if the petitioner is found eligible under the law for transfer, he shall be given opportunity of being heard in respect of available suitable vacancy. Interested? Paragraph 9, what is the difficulty? Same thing. Where is rejection? Nothing special, sir. Whatever is there, you will get it.
Then what the problem is now, it is suspended, we are not able to see the options given. So the already what has related to give the options.
Paragraph 8, any other judgments you want to rely?
I'm not arguing what she
There has to be the alternative arrangement, mother.
Have you CI? Where is the judgment? You could not kindly over a copy of that judgment, unreported judgment to him.
So I not for it.
Naturally, he is anxious. That is the reason he is anxious.
It might be.
You rely on an unreported judgment without handing over a copy. You're Mr. Lahiri.
Yes.
Not in time.
Yes, sir. Any difficulty in this order?
Well, here 6 months period has been mentioned, my lord. Yeah, well, if you also kindly records that if there is any alternative arrangement can be made, but not limiting to 6 months, my lord. Because if they, because they will again go for content, my lord, of the order, my lord, that will be difficult.
It's like, not standing the different options to decide.
The present writ application has been filed inter alia, challenging.
নামটা লিখুন।
There is no challenge. You are only saying that asking for transfer.
Yes. This is
Where is your rejection?
page 37.
Then where is the challenge to that?
This is the online portal. This is a portal.
Very well. So where is your challenge to that?
Yes. Can you take this back, sir?
Prayer.
Yes. Thank you. It is rejection. Which is the portal status?
Inter alia challenging the rejection of the petitioner's transfer application as reflected in the online portal of the authorities. What is your name?
Petitioner is Sonika here.
Serial number. Which is your serial number? Page 37.
No, this is, I explained, this is to be read from bottom. And it's read from 9. The HOI is the head of the institutions, forward is to the DI. No
I see.
from school. Side and enclosure of institution. Now, another DI can receive immediate service.
Very well. Where is the rejection? Come to the rejection show.
My can take the 20th of August 7. Student number 7 has decided in the meeting of
No reason.
under the aegis of basically government of West Bengal State of 31. Treaty and regard of the recommendations for transfer cannot be issued that is in cases where there is a single feature in the concerned circle.
So it has not been concluded.
No, that is a rejection. Now, subsequently, not telling you how the process goes on. Right? Now, subsequently, another rejection of by from the it comes back to head of the institution backs it to the applicant. Now, again, applicant makes an application. Head of the institution releases it with no objection to the DI. DI sends it to the head of the institution. Now, on this ground, it has not been proceeded further because it's already been decided.
Then
Commission is the highest authority because rejected my claim. After that, they will not proceed with that. So that is the commission for which it has been rejected.
application back.
Because the highest authority has already rejected.
Mr. Lahiri, learned advocate representing the petitioner, by drawing attention of this court to page number 37 of the writ application submits that from the online portal of the respondents, it would appear that the petitioner's application for transfer was taken up for consideration by the authorities on 30th August 2021. And the following observations were made. As decided, na, I can't tell. Since then, no further steps have been taken by the respondents. Post of it is submitted by Mr. Lahiri that the petitioner's application for transfer has in fact been rejected on the ground of a single teacher. On the ground that she is a single subject teacher. Post of. According to Mr. Lahiri, the aforesaid cannot form cogent ground for transfer of the petitioner's application by placing reliance on a judgment delivered by the division bench, by placing reliance on an unreported judgment delivered by the division bench of this honorable court in the case of Rupanjan Das versus the state of West Bengal and others in MAT 2061 of 2023 on 13th December 2023. They submitted that in identical set of facts, this on the division bench of this honorable court and directed the authorities to consider each case, to consider, had held that rejection of an application for transfer on the ground that the person is a single subject teacher cannot constitute a valid ground to deny the transfer. Cannot constitute a valid ground to deny transfer. It is submitted that the Honorable Court, the division bench of this Honorable Court, while setting aside, he said, order of rejection, had also directed the West Bengal Central School Commission to take up the petitioner's application for transfer in the said case through offline mode, in as much as the online mode, in as much as by a notification dated this is the notification, page 81.
The latest. No, this is not the.
In as much as the process for dealing with transfer application through online mode have been temporarily suspended. Full stop. Mr. Line. The petitioner's full stop. Mr. Lahiri submits that the petitioner being similarly placed with that of the appellant in MAT number 2061 of 2023, identical 2061 of 2023, similar benefits should be afforded to the petitioner. Mr. Das, learned advocate, representing who senior? Mr. Das. Mr. Das, learned advocate, representing the. You are representing the.
That's why I know. 1 to 6, 1 to 6. No, 1, 5 and 6.
Respondent numbers 5 and 6 submits that
1, 5 and 6.
1, 5 and 6 submits that by reasons of genuine difficulty being faced, by reasons of genuine difficulty, kindly hear this, by reasons of genuine difficulty being faced by the respondents, that the transfer application of the petitioner was kept in abeyance. Was kept in abeyance. First, in the instant case, they are saying it's rejected.
No, it is backwarded. Earlier also backwarded. Again, they applied.
Had been rejected. Full stop. Full stop. He submits that if similar, would I record that you have no objection to this direction?
No. My lord may not record that. My lord may record that if there is suitable replacement found in that area.
It is submitted that only in the event. It is only. His submission will I not record? It is submitted that only in the event a suitable representation, a replacement is found, that the petitioner's case can be taken up for consideration.
Yes.
That is all.
Yes,
Are the learned advocates appearing for the respective parties and considered the material on record? First of all, in the instant case, I find that the petitioner's case is similarly situated with that of Rupanjan Das, that a case of Rupanjan Das Supra. First of Supra, wherein it was observed that a single teacher may not, and that observe that a single subject teacher may not be ground to deny transfer if the petitioner is able to fulfill the other conditions. Full stop. Having regard to the fulfill the other conditions. Full stop. It is true that there may be various circumstances which may be exceptional and unique to the petitioner for considering his case for transfer, namely long distance medical grounds and other issues. Full stop. Having regard to the aforesaid, I am of the view that the petitioner cannot be denied the similar benefits as granted in favor of the appellant in Rupanjan Das. Full stop. As such, I set aside the order passed by the respondent. As such, I set aside the direction.
There is no such order.
Now, as such, I direct the respondents to reconsider the petitioner's case, as such, I direct the West Bengal Central School Commission to reconsider the petitioner's case for transfer through offline mode as the online portal is temporarily suspended, and take necessary steps for considering the transfer application of the petitioner in accordance with the transfer rules and amendments made thereon within a period of 12 weeks from the date of communication of this order. 12 weeks should be sufficient consideration.
Yes.
First up, in case paragraph, in case the petitioner is found eligible under the law for transfer, in case the petitioner is otherwise found eligible, comma, he shall be given an opportunity of being heard in respect of available suitable vacancies. Full stop. Paragraph 9, 10, 11. 9, that's it. Then the interest of the students and the school, since the interest of the school since the interest of the students and school are of paramount importance, comma, the authorities must find a suitable replacement. Authorities must find a suitable replacement of the teacher, comma, if the transfer application is allowed within a reasonable period of time, not exceeding 6 months from the date of decision on transfer. Full stop. The writ application, with the above observation and direction, the writ applications and disposed of, there shall be no other rest. She.
No. My lord, the School Service Commission is not represented. My lord, the respondent 2 and 3, the School Service Commission is not represented. It will be recorded on that.
Open affidavit of service will file on. Yes, yes.
Transfer matter. Now the issue is slightly different. Now there is also
5 minutes continue for 5 minutes. They have no, Hari, continue, sir. There is no difficulty. We are for this purpose, sir. Yes, yes.
But this is the transfer.
Yeah, who is appearing for the other side?
Lordship, I'm for the state, Lordship.
In instructions, madam?
Yes, Lordship. Actually, Lordship, this writ petition is not maintainable. There is a jurisdiction point regarding this writ petition, Lordship.
Yes, madam. What is the?
Lordship, the writ petitioner is working as the teacher in Raghunathpur, subdivision Raghunathpur under district Purulia, Lordship. And he would like to transfer into the district Kuch Bihar, Lordship. But that is the another question, Lordship.
First of all, the decision is to be there. Yes, yes.
These matters are previously taken up by the earlier benches and other.
Yes.
Because madam, it's a transfer issue. Now the residents of the petitioner is not going to she wants to come to Jalpaiguri. She wants to come to Jalpaiguri. She wants to get transferred to under DI of school.
So the DI of Jalpaiguri naturally will be invested with the. Yes, so part cause of action will be.
Transfer matters are different because there are 2 ways. 1, 2.
The commissioner can approach court
Proceedings is also covered by the already. What happened? There are 2 grounds. Grounds for general transfer and special transfer.
Yes.
But on the ground of distance and above 5 years of service, special grounds, health and other issues. So one of the grounds on the ground of where the petitioner made application, that is special transfer made application that was rejected on the ground that she has not completed 5 years of service, which is a requirement for general transfer. Now, this matter also came into the order division then whether this 5 years embargo will also applicable for
Health grounds.
on special grounds. Not only here, there are other grounds, physical, disability, health, divorce, many other list of grounds. So that issue came up before the order division whether this 5 years embargo will also be applicable upon this special ground transfer. The honorable division has categorically held that this 5 years embargo it is already annexed. I have already annexed.
Which page?
Page 97.
Madam.
Page 97. What they are.
Who has rejected that?
Lordship, first of all, Page 6, Lordship, first of all, page 96, which he has attached, Lordship. The photocopy of the Ushasri portal, Lordship, this is not legible. First of all, we have to decide who have rejected his pay.
Commissioner didn't really forward.
Which DI has forwarded this petition, Lordship, because that is the DI of Purulia, not from Jalpaiguri, Lordship.
That is a point I'll take into consideration.
Yes, Lordship.
Then on merit, now on merit.
On merit. On merit. So, Lordship, on merit, it can be considered, Lordship.
Since the TI of Jalpaiguri has not.
I'll hear your contention and give reasons for that. Why?
But there is no part jurisdiction.
अच्छा,
He has to consider, but something has to be considered by him.
Yes,
Merely adding him as a party will not.
They did
Sir,
not
in the
mean-
process of transfer,
Yes.
the vacancies will arise. Vacancy will be in Jalpaiguri.
Yes.
Now, the vacancies of Jalpaiguri is also required to be taken into consideration. So therefore, the
It is for Service Commission to consider.
Civil Service Commission will be required to take into consideration this aspect.
But his.
Now, yes, tell me, yes.
But his rejection is on a different point. Not that there is no vacancy here.
His rejection is on which ground?
5 years, Lordship.
Below 5 years.
Yes.
Now, he is saying that this is on health ground. If this is special grounds, not health, special grounds. If special grounds, then 5 years is not the criteria.
Special count allow by special count.
But
This is covered by the division bench.
but the circuit bench has no jurisdiction over the Purulia matter.
Sections 277.
We are confined only with 4 districts, madam.
And now it is the commission's rejection. Commission has central commission out of the West Bengal jurisdiction. And from there, I need to come to this, I need to join a school in Jalpaiguri.
He is working in a different district, madam.
Has to be his transfer matter.
I'll take into consideration your submissions. Ashu, anything else you want to add?
No, Lordship.
The present writ application has been filed inter alia, questioning the decision of the School Service Commission at page
Page 96.
whereby the petitioner's application for transfer had been rejected inter alia on the ground. I can't read it.
Number 2, I'm reading for you. Prayer is returned as date of present.
Inter alia on the ground that the petitioner had not completed 5 years of service. Where is your transfer application?
This is online.
No, where is the application? Where have you stated what was the reasons for your transfer?
So this is done through online, right?
Where have you stated that this is there are reasons for special reasons?
This is finding paragraph numbers.
Mr. Lahiri, learned advocate, representing the petitioner, by drawing attention of this court to paragraph 6 of the writ petition submits that the petitioner had not prayed for general transfer. He had prayed for transfer on special grounds. Accordingly, the commission had erred in rejecting the petitioner's application inter alia on the ground that the petitioner had not completed 5 years of service. Full stop. By drawing attention of this court to a judgment delivered by drawing attention of this court to an unreported judgment delivered by the division bench of this court in the case of Shubhadeep Gorai versus State of West Bengal and others in MAT 782 of 2023 on 24th of August 2023, it is submitted that in similar set of facts, The division bench, taking note of the applicability of Rule 3 and Rule 4 of
the general transfer rules 2015.
of the General Transfer Rules 2015,
Mine is under.
had concluded that Rule 4 is a standalone provision unconnected with the mandatory requirement of 5 years of satisfactory service contemplated under Rule 3 of the West Bengal School Service Commission within bracket general transfer, comma, transfer on special grounds and reallocation bracket close rules 2005. Having regard to the aforesaid, it is submitted that the petition is similarly placed and similar relief should be afforded in favor of the petitioner. First of paragraph, Miss
Bedashruti Bose, Lordship.
Miss Bose, learned advocate representing the commission.
Lordship,
Representing
state
the-
respondent, Lordship.
representing
State
all-
respondent.
No, identify kindly, madam.
আমরা কি কমিশনার করি? কমিশনার কই না। আমার ডিআই আছে, ডিআই জলপাইগুড়ি ওয়েস্ট বেঙ্গল আছে। 156.
এই কাগজে যেন লিখে দেয় তাহলে গন্ডগোল।
Respondent number 1, 5 and 6.
Respondent numbers 1, 5 and 6 submits that this honorable court does not have the territorial jurisdiction to take up this honorable court in circuit does not have the territorial jurisdiction to take up this matter. First up, the petitioner is working at Purulia. First up, the entire cause of action relating to this case has arisen in Purulia, and as such, no relief should be afforded to the petitioner. First up, on the ground of but rest is silent. So I've heard the learned advocates appearing for the respective parties and considered the materials on record. First up, the only objection raised by the respondent appears to be the territorial jurisdiction of this honorable court to entertain in circuit to entertain the present application. I find that the order which forms subject matter of challenge has been passed by the School Service Commission. Full stop. Although the petitioner is in Purulia, is presently working in a school at Purulia, yet where have you said that you are seeking transfer? Within this Purulia, yet the petitioner's place of residence is within the territorial jurisdiction of this honorable court in circuit. Full stop. The petitioner may very well be interested in seeking transfer. Where is your application for transfer? You have stated.
Paragraph 7, I will take paragraph 7. Petitions.
96
Last line to
96 ছিল অ্যাপ্লিকেশন। 95 কমিশনার।
Considering the nature,
তো ফরওয়ার্ড করেন।
considering the ground on which petitioner has sought transfer, the petitioner may well be interested in seeking transfer within the territorial jurisdiction of this honorable court in circuit, and as such, the DI of the relevant and as such, the commission would be required to take the views of the DI of schools, of the DI Jalpaiguri. Take the views of the District Inspector of Schools, Jalpaiguri.
Commission decides this.
No, views has to be taken. Views are not required.
No.
Views are not, commission decides.
That is the reason why I'm saying.
That's why commission has rejected.
My lord, considering the ground on which the petitioner has sought transfer, the petitioner may waive.
না এই দরকার নেই এটা তার আগে তো কি আছে
Director বলছেন যেটা হচ্ছে although the petitioner is presently working
তার আগে
school manner, I find that the order which means subject matter of challenge has been filed for the School Service Commission.
Full stop. তারপরে ঠিক ছিল কি ছিল although the petitioner
Although the petitioner is presently working school at really
Yet, since the decision of rejection has been passed by the School Service Commission, I am of the view that there is no, I am of the view that না তারা সরি এই লাইনটা গন্ডগোল হলো এর ঠিক আগের লাইনটা পড়ুন স্কুল ইট মে বি অল কি বললাম
but I find that the that which from subject matter of challenge has been passed by this service commission.
স্কুল সার্ভিস তারপর লাইন
Although the petitioner is presently working
at Purulia, the same cannot in my view denude this court of its jurisdiction to take up the present matter. First up, I find that in identical set of, I find that this honorable court, while I find the division bench of this honorable court in the case of Shubhodip Gorai, while interpreting the provisions of Rule 3 and Rule 4 of the West Bengal School Service Commission within bracket general transfer, now I get the said rules rules 3 and 4 of the said rules has concluded that Rule 4 is a standalone provision unconnected with the mandatory requirement of 5 years of satisfactory service contemplated under Rule 3 of the West Bengal School Service Commission. Having regard to the aforesaid and taking note of the peculiar circumstances under which the petitioner has sought for transfer, I am of the view that the commissioner is required to revisit the order of rejection, revisit the petitioner's application for transfer. First of in view thereof, the decision taken by the commission in its order dated
Decision dated 7th of November 2021.
Order dated 7th of November 2021 as is reflected from the online portal
Status.
Online portal status. A print-off whereof a printout whereof has been annexed at page 96 to the petition stands set aside. Full stop. Printout set aside হলো তো তাহলে আবার একবার লাইনটা পড়ো তো সরি
in view thereof decision taken by the commission.
Decision stands set aside. First up, the respondents are directed to revisit the petitioner's application on the basis of the observations made herein and in the light of the judgment delivered by the division bench of this court in the case of Shubhodip Gorai Sutra, which has been annexed at page number 97 of the present writ application. Such decision must be taken within a period of
6 weeks.
6 weeks from the date of communication of this order. Offline mode to
Offline mode and vacancy position.
তার আগে take into consideration তার আগে কি বললাম পড়ো তো reconsider দুটো লাইন আগে পড়ো
The respondents are directed to revisit the petition.
Respondents not the commission, the School Service Commission is just directed to revisit the petitioner's application
On the basis of the
for transfer on the basis of the observations made in
and in the light of the judgment delivered by the division bench of the Honorable Court in the case of Shubhodip Gorai within bracket Sutra, which has been annexed at page 97 of the present writ application.
in an offline mode.
Upon granting an opportunity of vacancy position.
So, in the event the petitioner is found eligible in accordance with the said rules and in terms of the observations made herein, the vacancy position shall be notified to the petitioner or shall be notified to the petitioner. The final decision thereon shall be taken by the respondent, taken by the commission
Recent order
on
may be
the
passed.
basis of the representation to be on the basis of representation to be made by the petition.
No, I again have to make application on that.
Representation, you will be notified of the vacancy.
Vacancy, amount of hearing may be given over there, it is done.
I see.
In all the matters, we are called, we go there, the options are given, we choose,
The last line of the
we give. No further representation is
found eligible.
In accordance with such rules, and in terms of the observations made herein, the vacancy position shall be
Notified to the petitioner
and The final decision
shall be taken by the authorities upon giving an opportunity of hearing
Yes.
to the petitioner. So the entire process must be completed within a period of 6 months from the date of communication of this order.
6 weeks.
So with the above observations, 6 months.
Weeks. Your lordship has already.
Fine, 6 weeks. 6 weeks from the date of 6 weeks. 6 weeks the decision.
Yes, what happens, they call us. After getting the order, they call us. So this is the order. You are
Within 12
eligible.
weeks. 6
12
weeks is the decision whether or not the
Yes, yes, yes.
eligibility.
Yes.
Thereafter the rest is there. So 12 weeks from the
12
date
weeks.
of.
Very well, man.
With the above observation, direction, the application stands disposed of, it shall be no arrest.
I'm grateful, extremely grateful.
Lordship, one indulgence, Lordship, there will be a small correction. I am for the respondent number 1 and 5, Lordship. Not,
Only.
yes, Lordship.
No, wait. Never.
Grateful, Lordship.
Never.
My lord, 12, I am for the petitioner, my lord.
Yes.
My lord, this is a matter, my lord, small matter, my lord. The goods were moving from Bardhaman to Siliguri, man. My lord,
Evidence is filed in court. Yes.
the goods were moving from Bardhaman to Siliguri, my lord. At
I'll-
the time of movement,
My lord, this the matter is recently assigned to me, so instruction is not here. So my request is.
but then I am coming on Wednesday, my lord. Let it be kept on Wednesday. My lord, physically I am coming, my lord.
Monday he said.
No. Monday I'm coming. Wednesday also I'm coming. My lord, I have a valid ticket, my lord.
No issue.
You will get instruction. Wednesday.
Next,
Thursday, my lord. My lord,
Mr. Agarwal, learned advocate representing the respondents, prays for an accommodation to take appropriate instructions in the matter. Let this matter stand adjourned and appear under the same heading Monday next.
covered matter, my lord. My lord, covered matter. Let them go through it. Covered matter.
Which one?
My lord, this 12.
5 minutes.
Grateful, lordship.
Yes.
My lord, I am on behalf of.
Before Lordship starts, my lord, may I beg for an indulgence?
Yes.
Lordship has been pleased to fix the matters on 11th, on this Monday, I guess.
The petitioner.
I am for respondent number.
I am for the petitioner, Lordship. Am I audible?
Yes, yes.
I am for the petitioner, Lordship.
Proceed.
Yes,
My lord.
the matter relates to illegal construction, Lordship.
Yes.
I have made a complaint against an illusion. I am the neighbor of the said land, Lordship. The complaint is that, Lordship, a parking plus 3-storied building has been constructed by a promoter on the land owned by respondent number 5 to 10. And this
Land owned by the respondent numbers 5 to 10.
Lordship.
Owned by the respondent numbers 5 to 10.
5 to 10, Lordship. And respondent number 4 is the promoter.
Yes.
I filed a complaint before the Commissioner, Siliguri Municipal Corporation. The complaint is annexed on page number 15, Lordship. The thing is,
Lordship, 287% will be completed.
Well, what steps have you taken?
No.
no steps they have taken, Lordship. They have not taken any steps, Lordship. The road is not 5 meter wide, and apart from that, they have not followed the sanction plan, Lordship. As per the sanction plan, they have to lift.
Affidavit of service 5 দেখি দাও ওটা দাও
287.
আচ্ছা আচ্ছা আমার কাছে yes. The petitioner complains of illegal construction. Full stop. It is the petitioner's case that the respondent number 4 has constructed a building in deviation to the sanction plan granted by the municipality on the
Municipal Corporation, Lordship.
municipal corporation on the property owned by the respondent numbers 5 to
10.
5 to 10. Full stop. It is submitted that despite making a complaint with the municipal corporation, municipal commissioner, municipal corporation on 19th of February 2024, no steps has been taken by the authorities. Full stop. Mr. Dhar, learned advocate representing the municipal corporation, on the other hand, submits that the municipal authorities are in the process of taking steps in terms of the provisions contained in section 287 of the West Bengal Municipal Corporation Act 2006. First of having regard to the aforesaid, I am of the view that no useful purpose will be served in keeping the writ application pending. Full stop. And let the aforesaid writ application be disposed of with the direction upon the municipal corporation disposed of on the commissioner. Commissioner is respondent number?
The commission is respondent number 2.
On the respondent number 2 to dispose of the petitioner's representation in accordance with the provisions of section 287 of the said act. To dispose of to decide on the question of unauthorized construction on the basis of the complaint made by the petitioner's representation dated 19th February 2024 in accordance with section 287 of the said act by giving an opportunity of hearing. ওই last line টা দরকার নেই, by giving an opportunity. In accordance বলা আছে ওর মধ্যেই আছে।
My lord, respondent number 4 appeared today.
Yes.
Respondent number 4.
Wait, who is respondent number 4?
Myself, I am representing the representative number 4.
আচ্ছা, ওই মিস্টার সাচ এন্ড সাচ ওখানে না, মানে ঠিক উল্টো দিকে ওনার পরে enters appearance on behalf of the respondent number. He submits that there is no violation. He submits that there has been no violation. He submits that the building has been. He submits that there is no unauthorized construction and that the construction has taken place in accordance with the sanctioned building plan.
Lordship, one more indulgence, Lordship.
Subhashish Ghosh.
Mr. Ghosh. Yes, তারপরে
One more.
লাস্ট কথাটা কোথায় ছিল বাবু?
যেটা বুঝি মানে To decide on the question of unauthorized construction on the basis of the complaint made by the petitioner's representation dated 19th February 2024 in accordance with section 87, 86.
The entire process must be completed within a period of 6 weeks. 6 weeks from the date of communication of this order. With the above observation and directions, if the application stands disposed of, there shall be no order restricted.
Lordship, one more indulgence, Lordship.
Since the respondents have not used any opposition, affidavit in opposition, since no affidavit in opposition has not, no affidavit in opposition has been called for, the allegations made in the petition are deemed not to have been
Sir,
admitted.
I will file written affidavit in opposition regarding. Let the reports come. Let them make the reports submit by that.
Not calling for any report.
No, miss.
Disposal করে দিচ্ছে যা বক্তব্য কমিশন
Okay.
So far as you are concerned, since you have not, no affidavit in opposition has been called for, the allegations made in the petition are deemed not to have been admitted by you. Deemed not to be admitted by the respondents.
Lordship, kindly give a stay on providing issuance occupancy certificate to the sellers if they sell the till the complaint is not been heard.
ওই আগে না যে মানে within period of 6 weeks ছিল, it is made clear that till such time a decision is reached, reached by the the municipal authorities are directed to ensure that no occupancy certificate is issued without taking a decision on the issue of illegal construction.
So
Deeply obliged, Lordship.
No.
the construction is already completed and they are in their possession, my lordship.
No, ভুল হলো। When have you completed construction?
Hello?
When have you completed construction?
It's completed almost 6 months back.
আচ্ছা, ওনার সাবমিশনের লাস্টে এখানে বলেছেন there is no deviation. It is he submits that the respondents have also, he submits that the respondent number 4 has already initiated the process for obtaining occupancy certificate.
Much.
Not necessary, sir, for this court to pass this order. Because if they do not comply with this and take steps, then this court has actual power.
Lordship.
Complaint is there.
Complaint is there, but already has much of it.
Obliged, Lordship.
টাইমটা ওটা ওই অকুপেন্সি টাইমটা ওরা দেওয়ার দরকার নেই, ওনার দেওয়ার দরকার নেই, এখানেও ইনজাংশন হচ্ছে না। Yes.
Continue only not to the lordship.
Why? Why? What is the matter? You do not want to do the matters.
Not to the
What is the matter? Tell me.
lordship.
And he's seeking compensation.
I'm in the course of
West Bengal victim compensation scheme, my lord.
Not today.
Oh, affidavit of service.
আরে petitioner
Petition. আমি তো অ্যাপিয়ার করছি, আমি তো পিটিশন।
Yes, sir.
আমি তো রেসপন্ডেন্ট, এফিডেভিট অফ সার্ভিস আমি
আচ্ছা, দুজনেই তো অ্যাপিয়ার করে গেছে,
অ্যাপিয়ার করে গেছে।
পরে অ্যাফিডেভিট অফ সার্ভিস তার কাছে থাকলে সে পরে এসে বুঝে দিয়ে যাবে, চিন্তা করবে না।
Well, I beg to appear on the petition.
Yes.
My innocuous prayer for consideration of my representation, which is pending before the authority.
What representation?
Transfer application. I have made application for consideration of my transfer that is pending before the authority. I am praying for consideration through the offline mode, and upon granting an opportunity of hearing, my lordship has also observed that the options have to be given. That much only.
Passover is asking for.
Very well. Very well. Similar prayer, same matter. Yes.
দেখি দাও।
This is my affidavit of service.
পনেরোটা আগে দাও, আগেরটাকে দাও।
Oh, my lord, kindly.
I have seen that.
15, yes.
Yes,
My lord,
madam.
Page 74 is my representation, my lord. Page 70.
Similar kinds of matter, similar.
Similar, it is similar.
হ্যাঁ।
কি matter? ওই consideration. 16, 17 একই দিয়ে। That is
Lordship,
pending.
this is similar kinds of matter. From the earlier occasion, your lordship has passed the same matter. Lordship.
Which one? Which order?
15, 16, 17 are similar matters.
No,
However,
I'm not
we are in
yet
15 years.
Not yet decided this issue.
Yes, yes. Praying for consideration, my lord. This is pending before the authority.
5 years you have completed, general transfer.
No, this is special on special ground. My wife's gynecological disorder, which is a statutory ground on which I can apply.
Where is the order?
38, page 38.
You
Is
have
it?
rejected it.
No, it is pending for their consideration. I'm only seeking consideration of my transfer application.
The present application has been filed inter alia, paying for a direction upon the
Respondent.
Civil Service Commission. The
No,
respondent.
commissioner.
Oh, the respondent number
2.
The respondent number 2 to consider the petitioner's application for transfer in offline mode.
On offline mode. Transfer application on special ground through offline mode.
Transfer application on special ground through offline mode in terms of the provisions contained in
West Bengal, page 38. No, 38 না, আগে আছে। 23. West Bengal School Service Commission.
Just a minute, just a minute.
Yes.
In terms of the West Bengal School Service Commission within bracket general transfer bracket close rules 2013.
15.
Was 2013?
15, my lord, 2015.
It is printed 2013.
Page 23, my lord.
Yes.
No, my lord, it's 2015. I don't know, my lord, whether there is any.
Go inside the notification.
Yes, page 23.
Yes.
It's page 2015, my lord.
What are you reading inside the notification?
Inside.
Powers conferred on the such and such.
No, short title and my lord, the commencement. The name of the rule is given there.
I see there.
There was a previous one.
The West Bengal School Service Commission within bracket general transfer, transfer on special grounds and reallocation bracket close rules 2015. Mr. Lahiri, learned advocate, by placing reliance on rules 3 and rule 4.
Rule 4, my lord. I'll be governed under rule 4. Only.
Rule 4 of the said rules submits that the petitioner's application has been made on special grounds. Full stop. As such, special grounds as identified in the said as identified in the transfer application. Full stop. Notwithstanding such application being made on special grounds, the said application has been kept pending and no decision has been taken by the commission. Miss
Vedasruti Bose, Lordship, led by Mr. Shubir Kumar Shah, LGP.
Miss Bose, learned advocate.
Lordship, we have only the one objection regarding the jurisdictional point.
Yes,
Lordship.
Miss Bose, learned advocate, you can enters appearance on behalf of the respondent numbers
1 and 2. 1 6, Lordship.
2 to Commissioner.
No, Commissioner, I'm not putting.
State to Commissioner of School Education.
No.
Government of West Bengal.
No.
That is GP service, government to the service.
Commissioner,
Yes. School Service Commissioner, Commissioner of School Education.
Commissioner, Alada advocate.
Commissioner of School Education, Government of West Bengal.
Alada
করবেন তো ওখানে তো তাই হয় No. State করেন
make up your mind, whatever you tell me, I'll record that.
No. State lawyers, my lord, I also appear from behalf of the state. I am ensuring
1, 2,
Lordship, 1, 2 and 6.
1, 2 and 6. Full stop. She submits since the petitioner is at present working at where is he working?
Yes, she is working at Murshidabad.
Murshidabad, Lordship.
Murshidabad. School, name of the school. Yes. Sheikh Dighi High School, HS, SHEIKHDI.
Where have you stated that? Which paragraph?
In cost title, para 7.
Cost title, paragraph 8. Paragraph 7. Yeah. Serial number 7.
Serial number 7, Lordship. Page 3.
Sheikh Dighi High School within bracket HS. Ramana Sheikh Dighi. As such, Ramana Sheikh Dighi, Murshidabad, as such, This honorable court in circuit may not have the jurisdiction to take up the aforesaid matter. I find that the application for transfer is required to be taken into consideration by the respondent number 2. Repeat residence of the petitioner. Where is your residence?
My residence is at, my lord, Kuch Bihar, district Kuch Bihar.
Yes.
Kuch
Kuch Bihar is also not residence of the petitioner.
Bihar
is that Kuch Bihar?
Yes.
The transfer has been sought for on special grounds. As such, it cannot be said that no part of the cause of action had arisen within the jurisdiction of this honorable court in circuit. In any event, the final deciding authority, since the final deciding authority is the respondent number 3, I am of the view that the writ application is maintained before this honorable court in circuit. The court had decided previously these points.
These points, no, it has already been allowed. This point was never raised before. These are first time hearing this.
Or the learned advocate, having regard to the transfer application filed by the petitioner and taking into consideration the fact that the petitioner has sought for transfer on special grounds in terms of Rule 4 of the said rules, which is a standalone provision, I am of the view that the respondents ought to have on the view that the respondent number 2 ought to have disposed of the petitioner's transfer application. Having regard to the special circumstances under which such transfer has been sought for, the respondent number 2 is thus directed to take into consideration the petitioner's application for transfer, and if the petitioner is found eligible, to make the petitioner aware of the available vacancies and to take a final decision on the basis and to take a final decision thereon upon giving the petitioner an opportunity of being heard. The entire process must be completed by the respondent number 2 within a period of
6 weeks.
6 weeks from the date of communication of this order.
6 months will be 6 months.
Special grounds.
Yes.
Special grounds. Special grounds. He is not asking for transfer on the ground that you are not rejecting it on the ground that there is no teacher available. Special grounds.
Yes. Through offline mode.
Offline mode.
Yes. Through offline.
Disposed of.
That is in my submission.
With the above observations.
Possibly that is in my submission. It is recorded in my submission.
Lordship, one indulgence.
1 minute, I give you.
The respondent number 3 is thus directed to take into consideration the petitioner's application for transfer, and if the petitioner is only eligible to make the petitioner aware of the available vacancies and to take final decisions thereon, then giving the petitioner an opportunity of being heard. So the entire process must be completed by the
6 weeks.
within a period of 6 weeks from the date of communication. So that
take into consideration the petitioner's application for transfer through offline mode. Yes, madam. Sorry.
Affidavit of service.
Yes.
Lordship, kindly make it 8 weeks instead of 6 weeks. Get full.
Affidavit of service filed in court.
Yes, I have submitted. The similar prayer. This is also on special ground. 81 is my representation.
I represent the state government under 1 to access.
2720. 2720. Next, M 272.
Identity. Offline mode. Please put them. Where is your application?
781, my lord.
2722.
81.
722.
No, page.
2722 এবার দাঁড়াও।
ওই স্পেশাল গ্রাউন্ডস উপরে পিটিশনের সাবমিশনে মানে আছে না পিটিশনের সাবমিশনে
Oh, name of the school. Thank you. দিলাম তো এপিডিবিটি।
না বলার দরকার নেই, আমি কেন নথিখানে ঢাকবো, যা আছে।
My lord, the district would be different and the name of the school, as your lordship mentioned in the earlier order.
Oh, same objection are you taking?
Same objection.
বলে দিচ্ছি দাদা, কেন ওখানে গন্ডগোল হয়। বিকেল বেলা আমাদের মাথা পাঠবে, ওরা তো চলে এলাম। এই জালক বিদ্যালয়, পশ্চিম মেদিনীপুর।
Yes. Petitioner কোচবিহার।
এখানে একটা করে দিও, একটু আমি চেঞ্জ করে দিতে দেখি, এটা বলছে তো। Where have you stated that this court has cause of action?
Well, this issue has never arisen, so my lord, since between the two districts,
You are working in Paschim Medinipur.
Paschim Medinipur, yes.
Resident of this place.
Kuchbihar, yes. I want to come to a school here.
বলা আছে তো আগেরটা resident of Kuchbihar. এটাও তাই, same order.
এটা এফিডেভিট সার্ভিস আছে, ঠিক আছে।
My lord, the similar prayer, this representation is at page 76. My lord, only one thing, there is a procedure there to be complied with, because it will be sent to CMOH also for medical verification. If your lordship kindly records and observes that upon completion of the procedure as contemplated under the rules. Your lordship has already said that, yes, that because it would
Page,
be page 76.
Yes, কি order টা আরেকবার follow করুন। আগে দাও। If found eligible,
The response number is as directed to taking into consideration the petitioner's application for the transfer to offline mode, and if the petitioner is found eligible, to make the petitioner aware of the available vacancies.
yes.
Found eligible, your lordship hold.
What are you saying? What is the submission?
Because there is, suppose my lord, there is a medical, on ground of medical, I am applying, I should be treated through the CMOH also. So there is a procedure laid down. So my lord, that in accordance with the procedure as laid down under the rules.
That is obvious.
Yes, because it channelized through the CMOH.
Found eligible.
Found eligible, very well. Now this is page 76.
In terms of the which rules?
2015 rules, same rules.
Found eligible in terms of bola.
Yes, it is.
এই লাইনটা এই প্যারাগ্রাফটা
The paragraph is শুরু হচ্ছিল having regard to the transfer in terms of in terms of rule 4 of the said rules, which is standalone provision and a degree of the responding of the ought to have disposed of the petitioner's transfer application having regard to the subject special circumstances under which the said transfer has been sought for. However, the response number 2 is thus directed.
Paragraph, thus directed
to take into consideration the petitioner's application for transfer through offline mode, and if the petitioner is found eligible to make the petitioner
eligible in terms of the said rules.
This is my lord 76. Yes, grateful. I'm grateful to you, Lord. Extremely grateful.
I'm not incorporating the respective dates in the application.
Yes,
because that will apply.
That would apply.
ঠিক আছে? কোনো দিন দেখো না তুলো না ধরো দেখবো সেট রুল সব তিনটেতেই হবে একই অর্ডার
Said rules. That would be more clear on that. Grateful.
In this application, praying for implementation of the
pen drive
order passed by the
pen drive শুধু কাগজই হবে
in this equation, praying for implementation of this order passed by the Commissioner of Municipal Municipal Corporation. Page 73 is the demolition order. passed on 2nd March 2024, but till date it has not yet been implemented, madam.
No, Lordship, my instruction is that already the notices have been prepared, but only ensuring for the purpose of ensuring election, the things will not have been demolished.
Take instruction, come back.
Lordship.
Having regard to the nature of allegations made in the petition, I am of the view that respondent should be directed to file a short report indicating the steps taken by the respondents in connection with demolition.
No, demolition notice at page
73, madam, P9.
P9, 2nd March 2024.
No, this is a representation. Which is
No,
yours.
this is the order of the commission.
Page.
Page
73, madam. Annexure P9. 75 is the operating portion, madam.
Having regard to the nature of allegations,
Petition, I am of the view that the respondent should be directed to file a report indicating the steps
taken by them in furtherance to the order dated 2nd of March. Second of March 2024, such report should be filed on or before the matter is taken up next. This matter for further consideration Monday. Next.
And madam, one thing, madam, that since the corporation has asked the private respondent to stop the construction work, they are continuously carrying on. Now they are
Monday, I'm asking for a report, sir. Without the report,
Madam, FDO service may take on.
the other matter, there was a special direction. They did not comply.
Madam,
Affidavit of service filed and could be taken on record. Yes, they call the next matter.
In the meantime, if the elections will be open, in the meantime, if the corporation complies with the order.
This order shall not prevent the corporation. This order shall not stand in the way of the municipal authorities from taking further steps in furtherance to the order dated. ওই ডেটটা দিয়ে দাও।
Lordship, that- হ্যাঁ। 19. 18 আমি দৌড়ছি না।
I'm appealing for the WBAC.
Yes.
হ্যাঁ।
You are appealing for
WBAC.
electricity. What is the matter, sir?
I'm the petitioner.
Yes.
Yes. I have purchased a garage.
I beg to appear on behalf of the private respondent.
Yes, Mr. Bhattacharya.
My affidavit.
You do not.
Private respondent, my lord. Madam, I have also filed an application challenging the same order, which is scheduled to be appear on 26th, my lord.
You want to stand in the way of the petitioner getting connection?
Lordship, in this matter, the private respondent, they are the developers. So they.
Item number 18, my lord. I am on item number 18, my lord.
18 is over. 18 next date, Mr. Bhattacharya.
But 18 has
18 is
been passed over or order has been passed.
passed.
My lord.
Mr. Bhattacharya, 18 order has been passed. I have called for a report from the authority. কি শোনা যাচ্ছে না কেন? শুনতে পাচ্ছে না কেন? I have called for a report from the authorities. Can you hear me?
Yes, my lord. I can get you. I am now. Am I audible to my lord?
In the previous matter, I have called for a report from the authorities.
The lord has passed an order for report from the authority. But what happened, my lord? I have also filed a writ petition.
Mr. Bhattacharya, matter is over. Monday. You can't argue it now since you have come online. I have just.
It is not getting, man. I am not getting. I was not getting the connection. I was in the line, man. Anyways, my lord.
Monday.
As your lordship.
Day.
As your lordship, please.
Yes. You will take your stance from Calcutta. What will happen? This will happen.
But I will be there on Monday, my lord.
Now, I purchased a garage for the purpose of parking my vehicle there, my four-wheeler vehicle there. Now, the owners of that residential building.
You want a connection there, electricity connection there?
Yes, I want to install a CCTV camera for the protection of my car.
Garage CCTV camera.
Yes, look, kindly take some.
The private respondent, the developers, they have applied for connection because it's a flat, so connection should be given at first, B connection, thereafter A connection should be given. So they have not paid the quotation amount. How can the connection be given?
I have made my representation. Let them. They have kept.
B connection is given. How can there has to be a transformer has to be installed. Otherwise, connection cannot be given.
Kindly comes to
Yes.
my kindly comes to my representation. My
How can you get the connection and without the transformer? Who will supply you? Very well. I will record that you are ready and willing to put in the entire cost by the respondents.
No.
Yes, naturally.
He is taking this. He is giving me answer now, but he has kept my application pending.
He will dispose of your application.
Yes.
Ask him to put in the cost.
No.
I will record your submission. Where is the developer?
I have served on everybody.
Where is the developer?
No, Lordship, the area is at.
Raju Bose.
Yes, the.
Who is the developer? Who is the developer? If you are ready and willing to put in the cost of transformer, I'll permit you to get electricity connection here and now. Ali sir, you have taken up a residential plot. Where is your agreement?
No, yes, the deed of purchase is at page. It starts from.
Does it entitle him to get separate electricity connection?
How can he give?
Find out from the agreement. Tell me, sir. He has disclosed the agreement.
Yes, I have a specific area I have purchased.
Oh, paragraph 14.
Unless the developer.
No, paragraph 14. Purchaser shall obtain her own electricity connection from the West Bengal State Electricity Distribution Company in his own name. Take instruction in the matter.
Unless the
Proportionate charges he'll pay. Proportionate charges he'll pay for the transformer.
The charges is around 5 lakh.
Proportionate charges he'll pay. Find out how many persons will get electricity. He will pay proportionate charges.
No, Lordship, it is not a case that nobody is getting electricity. All the flat owners are getting electricity.
No, that connection is from the earlier connection.
So providing that.
I am asking for a separate electric meter, electric connection.
Take instruction, sir. Take instruction in this matter. Come Monday. The matter pertains to grant of new electricity connection. First of having regard to the aforesaid, let this matter stand adjourned and appear under the same heading on Monday. Next Monday date diye dao. The respondents are directed to take appropriate instructions in the matter. Next. Kuri ডাকবে।
তোমার অফিস বন্ধ। হ্যাঁ দেবো।
Affidavit of service filed in court BT10 with the record. Over. Yes, 20. Yes, sir. You are appearing. Yes, what is this matter?
Yes, Lordship, I have challenged this order. Order is page at 107 and 108. This order has been passed by the Inspector General, Frontier Headquarters, SSB Siliguri.
Yes.
Yes. Now, Lordship, there was an allegation against me.
Under what provision? 153.
This order has been passed, Lordship.
Inquiry under 153.
Inquiry has been, summary trial has been done. And
by the summary security force court.
Yes, the SSB, Sajusta Simabal.
Yes.
And they have passed this order after the recording of evidence.
Have you been dismissed? What happened to you?
No, severe reprimand. That because the charges have not been proved against me. Only kindly come to page number 45, the charge sheet.
Yes. Did you prefer an appeal?
Yes, appeal preferred.
Revision?
Yes, appeal preferred. Appeal.
Revision?
Pending. Revision.
Revision is not over, sir. Let me dispose it off. Yes, sir. Revision is pending. Sir, direct the revisional authority to dispose of.
Lordship, before I make my submission, let me confirm. Malad, I stand corrected, revision is over.
Where is that order?
He has not annexed it.
You have it?
Yeah. Revision got ordered.
This is
Actually,
the
Malad, I received the read today.
It doesn't matter. Let me go through. Let me go one
So I am not very.
Lordship only comes to page number 45, this thing, the charge sheet.
What is the charge? What is the charge?
Yes, kindly see. The charge is that under section 22C, using insubordinate language to his superior officer. This is the first charge. And the second charge is being an officer, behaving in a manner unbecoming of his position and character expected of him.
Yes, so.
Yes. First charge is I have used insubordinate language to my senior, and second one
Are you
is
permitted to? Are you permitted to? You're not permitted.
I have not used.
So where is your defense statement?
Yes. No, can we come to the order first?
Yes.
I am reading from page number 108, Lordship. And whereas the middle portion, and whereas the undersigned, after taking into consideration all documents and facts under consideration, found that charge 1 framed under 22C of the SSB Act using unsubordinate language to his superior office is partially proved. But proved to the extent that charged officer has spoken unparliamentary words, but none of the witness.
Where are you reading?
From the middle portion.
Page?
Page 108. This is the order of punishment.
Yes.
Middle portion, Lordship. Third paragraph from the bottom.
Charge 2 is fully proved.
Yes, how charge 2 is fully proved?
Unbecoming. Partially proved.
I have not, they could not prove that I have, whether I have uttered unsubordinate language to my senior. Kindly see, Lordship.
Again, read it. Yes.
Yes. Charge, I am reading, Lordship. Charge 1 framed under section 22C of the SSB Act using unsubordinate language to his superior officer
is partially proved to the extent.
Partially proved
so the charge officer had spoken unparliamentary words.
But none of the witness except Sri Rishikesh Srivastav, the then 21C commandant, has specifically been able to bring out that unparliamentary words were spoken for Sri BK Pal. The BK Pal is the complainant. Full stop. Sri Rishikesh Srivastav, the then 21C commandant, in his statement stated that unparliamentary words were spoken to Sri BK Pal, but during the course of examination by the accused, but during his cross-examination, he has clearly stated in response to question number 1, question number 11, that name of Sri BK Pal DIG was not uttered while in response to while in response.
So you did speak, you did utter something which was unparliamentary. I'll conclude this after I come back.
But what is the charge?
Sir, you understand,
It
sir.
was to my senior.
Please understand.
To my senior.
We are in a disciplinary proceedings.
Lordship.
The charge is proved on the basis, this is under a summary security force court.
Lordship.
Because he did not think it fit, he had sent it to the summary command, did not consider it. I shall go through the records. The records are here.
No, my lord, we received it only today.
Bring the records.
We will.
Tomorrow.
Lordship, let it be on Wednesday.
2 p.m.
Wednesday 2 p.m.
This is a hearing matter. If you don't want to do the hearing matter, best thing to admit it and keep it for the gallows. So it will remain for 10 years now.
My lord, we have disposed of all the cases that we have. We have not, we do not only see that.
No. But if the parties are interested now, after going through the records, I do not know what once I go through the records, then I'll be in a position to ascertain what will happen in.
My lord, I have not also gone through the records, but whatever I had spoken to the deputy.
One thing, if the records come and I take it up, this matter will come to an end whichever way it goes.
So that is the only logical conclusion. Either he wins or I win. There cannot be a third way.
Yes, very well. Since the petitioner questions, the questions, the final order passed by the summary security force court. Where is that order? Finally, it's by the summary security force court. Where is that?
Page 107 starts.
This is by the summary security force court.
No, this is by the Inspector General.
Well, this is summary trial, not a
Summary
court
trial.
court.
After the
Oh, not summary security, summary trial. Oh, this is summary trial. So summary
Evidence
trial,
have been taken.
summary trial is minor penalty only.
Yes, my lord. He has been given severe reprimand.
Without proving the charge, why should I take a reprimand?
How will the reprimand be taken back?
Summary trial conducted in accordance with summary trial conducted by the, who has conducted this? The Inspector General has not conducted this.
Lordship, IG himself.
IG has conducted.
Yes.
Summary trial conducted by the Inspector General.
And that is why he is a respondent.
Inspector General,
Inspector
Frontier
General-
Headquarters, SSB Shiliguri. The petitioner challenges, then questions. And the consequential punishment and the subsequent order passed by the appellate authority dated
dated
24th January 2024.
No.
23rd January
23rd January 2024.
2024.
That is the appellate order. 13th September 2023 is the order of the IG. Mr. Dhawar, please check.
Yes. No. 13 is order.
On 23rd January 2024.
That is the
Let the records of this case be produced by the respondents. Full stop. List this matter for further consideration on Wednesday.
2 p.m.
Wednesday. Full stop. This shall be taken up as the first hearing matter. It shall be taken up as the first hearing matter.
Yeah,
Sir, records, if the records do not come, nothing will happen.
No, we will produce the record. We will produce the record, madam.
Chalo. Motion over. See, on the basis of preponderance of probabilities, A. Secondly, if something is there, like the tribunal proceedings, the court will not interfere. Something.
So I understand, but subject to correction.
It is not on the basis of proof beyond reasonable doubt. Preponderance of probability, the court will not interfere. Something is there.
My humble understanding that is with regard to the departmental problem. But here the evidences have been taken.
No, sir, same. Same principle applies. Same. No, this is not a criminal proceedings. I'll clarify that position. If you can show nothing, yes, it is also possible.
Nothing against the complainant.
Nothing is also possible. It is also possible that the entire charge, none of the charges were proved. None. You are saying charge 1, charge 2 is dependent on charge 1.
Yes.
And I have got your case.
Yes.
So I'll hear you on that.
petitioner.
For the state, my lord.
Yes,
Lordship, I have filed the affidavit of service.
yes, what are you claiming?
Lordship, I am for the petitioner in item number 21, Lordship.
Yes,
The matter relates to interest on gratuity, Lordship. Am I
yes,
audible, Lordship?
yes, I can hear you.
Am I audible, Lordship?
Yes, I can hear you.
Yes, Lordship. The petitioner was appointed as an assistant teacher of a government-aided high school, Lordship.
Yes,
And she superannuated from her service on 31st day of December 2022.
yes,
And her pension payment order was issued on 5th October 2023. So
yes.
she is praying for interest for the delayed payment of gratuity, Lordship.
গুলো আছে আছে কেন আছে আছে The present application as a DA, the present application has been filed indirectly applying for interest on payment of delayed payment of gratuity. Post of the petitioner was appointed as an assistant teacher of Krishna. Yes, that assistant teacher of Krishna Maya Memorial Nepali High School, situated at Hakimpara, Siliguri. Post of the petitioner had since retired from service on 31st of December 2022 after performing her duties for a period of 36 years. After performing her duties, his duties, for a period of her duties.
Her duties, my lord.
Our duties, Lordship.
Duties for a period of 36 years.
Lordship.
Post of according to the petitioner. When did you receive the payments?
On 10th day of October 2023.
Where do I get it?
Lordship,
Where do I get it?
from the list of date sections, Lordship.
No, from the document, no document.
Yes, document is there, Lordship. At page number 11, Lordship, I have annexed the pension payment order, Lordship.
This is pension order. What about your gratuity? Is only on gratuity.
Lordship.
According to the petitioner was released gratuity. In terms of the pension payment order dated, you were released gratuity on the basis of pension payment order.
Lordship.
Where have you said so?
In the pension payment order itself, Lordship.
No, where have you said so in the petition?
Lordship, I am referring the specific paragraph, Lordship. At paragraph number 4, Lordship.
Released gratuity.
Page number 3.
In terms of the pension payment order dated 5th of October 2023. According to the petitioner, although the petitioner was obliged to be paid gratuity within 30 days from the date of her retirement, this has not been done. Instead of having regard to the aforesaid, he prays for disbursal of gratuity. He prays for payment of interest on account of delayed payment of gratuity in her favor. Her. First of learned advocate, Mr.
Sarkar, led by Mr.
Mr. Sarkar enters appearance. Enters appearance on behalf of the state respondents. First up, or the learned advocates appearing for the respective parties and consider the materials and record. Full stop. Ordinarily, a gratuity is payable to an employee immediately on his retirement. Full stop. In the instant case, I find although the petitioner had retired from service, immediately on a retirement, full stop. Ordinarily, gratuity was processed, or ordinarily an application for gratuity is processed prior to the retirement of an employee. Full stop. In this case, it is noticed that the petitioner had retired from service on 31st of December 2022. Full stop. Unfortunately, the gratuity was disbursed in favor of the petitioner after nearly 10 months from the date of retirement. First of having regard to the aforesaid, I am of the view the respondents cannot be permitted to. I am of the view that the respondents are bound to compensate the petitioner on account of delayed payment of gratuity. First of What is ordinarily permitted?
8%, Lordship.
Why?
Lordship, I have several orders passed by the coordinate benches of this court, Lordship.
Why? Why not 10% as per the payment of gratuity?
Yes, Lordship, I have no objection if the court grants 10% to me.
Not?
Milord, it is usually 6 to 8% is allowed.
Why? Why will you not pay 10% for having delayed payment of gratuity? That is a statutory rate. Taking into consideration the fact that the respondents, taking into consideration the fact that the respondents were obliged to make, again, line ki bole ji cannot deny, bole diye already, na? In view thereof, the respondent shall pay interest at the rate of 8% on the delayed payment of gratuity to the on account of delayed payment of gratuity to the petitioner for the period on account of delayed payment of gratuity to the petitioner from the date of retirement till such time the same is actually disbursed. Full stop. Yeah. Till such time the same is actually disbursed. Full stop. Petitioner on account last line কি বললাম entitled না direction আছে paid with the observation directions the writ application stands disposed of there shall be no other to post.
Lordship, kindly fix a time limit, otherwise they shall drag the matter for one more year, Lordship.
You get interest at the rate of 8%.
Obliged, Lordship.
Bank interest you will not get 8%.
Lordship. Obliged, Lordship.
It is expected at the line there. It is expected that the it is expected that the respondent shall process the petition, the payment on account of process the payment of interest on account of delayed payment of gratuity as expeditiously as possible, preferably. No. Whatever time they take, I have directed till such time amount is not paid, you will be entitled to interest.
Lordship.
Grateful.
Carry item number 22.
देखिए फाइल देखिए None appeals for the petitioner. No accommodation has been sought for. In view thereof, let this matter be dismissed for default. দেখি ক্যানটা কি ডিসমিস না করলে হবে না, তো কেউ পড়বে না, শুধু বলছি যে মামলা হচ্ছে না। ইন্টারিম অর্ডার আছে নাকি আগের পাতায় দেখতো ইন্টারিম অর্ডার আছে, নেই, মামলায় শেষ। Can't you file anything? We can file anything. But the present application along with the connected application stands dismissed for default.
Ma'am, on behalf of the petitioner.
Yes, proceed, madam.
In this matter, my lord, if you should kindly seize the last order passed by Justice Sarkar, my lord. Since they have challenged the virus of the DI fund management, my lord, hence rules, my lord, then hence a copy was they were directed to serve a copy upon the learned additional advocate general. My lord,
if you are not served, I'll dismiss it.
no, my lord, what has come to my knowledge that he himself is personally involved in this matter, so he cannot take the charge of this matter.
He served on his office. What are you saying?
State has appeared since he cannot appeal.
Advocate, it has been served on his office. Office, he will depute someone else.
My lord. But in that case, my lord, there was direction for.
Complied with this, madam? Petitioner,
Yes,
have you complied with the direction or not?
Lordship, there was a direction for affidavit in opposition on behalf for.
Have you complied with the direction dated 23rd November 2023?
Lordship, I need to take instructions from my senior.
Additional Advocate General is appearing in the matter.
Lordship, he is now, right now, he is for the states and he was personally involved in this matter on behalf of the petitioners. That
Does not matter, someone else will be there. Since it appears that by order dated 18th of October 2023, what are you paying? What are you paying? You don't want to do the matter.
Lordship, I have to take instruction. The affidavit must be,
But there was direction to exchange affidavit. That has not been.
that is not complied.
I'm seeking extension of time to.
Affidavit in opposition. Lordship,
Have you
order-
paid cost 10,000 rupees? Have you paid the cost?
No, Lordship.
Today, Mr. Successor Learned Advocate representing the state respondents once again prays for an extension of time to file the affidavit in opposition. Full stop. Records, however, reveal that by order dated 18th October 2023, this court, a coordinate bench of this court, as in way of a last chance, had extended the time for filing affidavit in opposition by the respondents by a period of 2 weeks after the puja vacation, subject to payment of cost of rupees 10,000 to be paid to the State Legal Aid Service, Jalpaiguri. And the respondents were directed, state respondents were directed to file payment of proof before this court. Full stop. Mr. Such Learned Advocate such is unaware whether the aforesaid submits that the cost has not been paid. Submits that the cost has not been paid. First of having regard to the aforesaid and taking note of the fact that the state respondents are not interested to comply with the directions. I'll record that. Submits that the cost have not been paid. So he submits that by reasons of oversight, the aforesaid deposit has not been made. Full stop. Having regard to the aforesaid, oversight, the cost has not been paid. Full stop. Having regard to the aforesaid, I am of the view that it, however, appears that notwithstanding seeking an extension, the respondents have not filed their affidavit in opposition. Today, once again, the respondents seek for that time to file their affidavit in opposition. Although the conduct of the respondent does not appear to be conduct of the state respondents, is not appreciated by this court. However, as in we have a last chance, time to file the affidavit in opposition is extended by this court, subject to payment of cost of rupees 50,000 to be paid by the state respondents to be paid to the State Legal Aid Service, Jalpaiguri, in addition to the payment of cost already directed to be paid by order dated 18th October 2023. Full stop. The state respondent shall file payment of proof of the same before this court on or before the matter is taken up next. Full stop. The petitioner shall be at liberty to file its reply within 2 weeks. ওখানে আগে কত দিয়েছি টাইমটা বলে নিন করে দিন how much time you require 4 weeks
Initially 4 weeks was granted.
another 4 weeks ওখানে বলুন 4 weeks the petitioner shall be at liberty to file its reply within 2 weeks from the date within 2 weeks thereafter. Stop. List this matter for final hearing in the monthly list of list bolbo na list this matter for final hearing in the monthly list hobe na in the first available circuit in the month of July 2024. Yes, 1 lakh.
Grateful Lordship.
50,000. This you have to pay. You have not complied with the direction.
Because I was sick, I think only having engagement back and for 300 hours something sick. That's a bit over.
আরো 10,000 টাকা করে দিন 50 টা কমিয়ে 10 করে দিন no cost you have to pay
Cost I remember and
additional cost you have to pay another additional cost that is the reason why you were not well I've reduced it but additional cost you have to pay
yes
10,000 no 10,000 it's all right no 10,000 not your pocket sir 10,000 you have to pay that I have because Justice Nizamuddin, Honorable Justice Nizamuddin and observed that. I cannot ignore it. You have seen the order. I reduced it to 10,000. Yes.
that amount initial amount
No, in addition to that, you have to pay. I cannot reduce it below that amount. Below the Honorable Justice Nizamuddin has. আরো 5,000 টাকা করে দিন 5,000. Yes, call the list.
Grateful Lordship.
Sir, object is to ensure this comes. But you cannot disobey directions passed by the court.
Lordship, 24, 25 and 26, your Lordship, kindly keep the matter out of list, your Lordship.
Why? Why you want to do that?
Dismiss instructions I have received.
Interim orders?
No. Separate matters.
Huh?
They are separate matters, not identical.
Is she enjoying an interim order?
No.
What is the matter? Let me dismiss the matter, madam. You are complaining matters are not being taken up. Yes?
Your Lordship, I'm not aware of this matter because I'm not involved in this matter, your Lordship. The instructions which I received, that is to keep the matter out of list. There's 3 matters, your Lordship, 24, 25 and 26.
The petitioner seeks for delisting of the aforesaid matters. First of having regard to the submissions made by the petitioner, I am the view that the petitioner is not interested to move the aforesaid matter. In view thereof, let this matter be dismissed for want of prosecution.
Liberty to mention.
So I have dismissed the matter, nothing.
Yes.
You understand the consequence? In view thereof, let this matter go out of the list with liberty to mention after 16 weeks. আচ্ছা রে 16 3 আরো পরে 20 weeks.
This is already become an inappropriate. Petition has become inappropriate 26. Separate matters.
The আচ্ছা 16 সপ্তাহ আছে অত 16 সপ্তাহ এটা থাক 16 সপ্তাহ ইয়েস পরেরটা দেখি
25 also same, your lordship. 25, no, 25 and 24, 25, 26, your lordship.
yes
Maybe, but my prayer is the same prayer, your lordship.
yes what is your submission? Who is appearing for the respondent? What is his prayer? Has the panel been published?
Yes, 25 and 26 are identical matters. Already, when selection procedure has been commenced, selected list of selected candidates has been duly published.
By way of the present application, the petitioner prays for publishing the panel for the post of auxiliary fire operator on contractual basis for Alipurduar district under the West Bengal Fire and Emergency Services. And for consideration of the petitioner's candidature. Full stop. Miss such and such learned advocate representing the petitioner prays for delisting of the aforesaid matter. Full stop. Mr.
Hirok Borman.
Mr. Borman, learned advocate representing the state respondent submits that the entire selection process submits that not only the panel for the post of auxiliary fire operator and contract of not only the panel for the post of auxiliary fire operator has been published, but the entire selection process has long been completed. Has long been completed and the appointment long been completed.
We have also filed affidavit in opposition. We have given list of annexed list.
Long been completed. Full stop. By placing reliance on the affidavit in opposition filed on behalf of the respondents, by placing reliance, by drawing attention of this court, to the list of selected candidates as appearing from the letter dated 6 January 2021 issued by the Director General, West Bengal Fire and Emergency Services, it is submitted that already the posts had been filled up. Posts have been filled up. It is submitted that nothing survives in the present application. He submitted that the present writ application has become infructuous and nothing survives in the present application. First off, I find that I find that although the writ petition had been filed complaining of irregularities in the selection process, the petitioner does not appear to be interested in proceeding with the present application. Instead of having regard to the aforesaid, I am of the view that the present challenge cannot be permitted to be retained on the file without the petitioner proceeding with the same. Full stop. This apart, since the entire selection process has already been completed, I am of the view that the present application, this apart, since the entire selection process, as rightly pointed out by the learned advocate for the respondents, has been completed, nothing survives in the present application, and the same is accordingly dismissed. There shall be no order as to cost. My last line that we got a dismiss column. And taking note of the fact that the petitioner is not interested to continue and taking note of the fact that the petitioner is not interested to press its challenge, the writ application stands dismissed. There shall be no order as to cost.
Last occasion, direction was given to file a reply, my lord.
You have said you want delisting, that is why I've dismissed it. Yes.
Same, identical.
Identical. In the interim order.
21 same.
You want to proceed with the matter?
Yes, my lord.
Proceed.
But one day tomorrow. But if you reply, my lord, we have filed a reply, my lord. We have made out.
What reply? What is your challenge in the selection process? Tell me, show me, sir.
My lord, we have, according to our submission, my lord, the videography was made. According to their statement, my lord, according to our records, my lord, they have stated that the two lists made, my lord, and one list, subsequent list, my lord, my roll number was different for this, my lord. But so far I can recollect, my lord. And my whole
tomorrow.
Both matter, my lord.
Tomorrow. No, that is over. I have decided that already. This one only. Yes. Tomorrow.
Same matter. Both matter, my lord.
I have decided that. If you want to, why were you not here? Your junior was asking for time not to proceed with this.
My lord, kindly, my lord.
That is over. I will not adjourn that. Yes.
26, my lord.
Lordship 27, I'm on behalf of the petitioner.
Yes.
There was direction to file affidavit in opposition on behalf of the respondent authorities.
What is the matter, madam?
Lordship, I'm not the conducting.
Then why are you here?
Instruction from my senior.
My lord, this matter also, my lord, I appear for the respondent Union Corporation, my lord. This matter also relates to a tender which has been closed long back. Tender for transportation of fuels, my lord.
These are all, why do you instruct your applications? Why do you want to retain them on the file, madam? I'll impose cost while dismissing applications. If I dismiss applications, I'll dismiss.
Pass over for few minutes.
Yes.
I'll take instruction.
Yes. If you want to withdraw it. Otherwise, I'll impose cost. You can't retain these matters on the file.
Lordship.
Yes, take instructions. Yes. Call the next matter, pass over.
For the petitioner, I'm just going, Mr. One, but there was direction for upon.
Virtually.
And I beg to appear on behalf of the respondent number 6 and 7.
Yes.
Our affidavit is ready. We seek 3 days time before the election. Affirmation is pending.
You did not pay the compensation.
No, their land has never been acquired. That is our.
Who is for the petitioner?
I am for the petitioner. I'm just going, Mr. One.
Yes, your land has been acquired.
Yes, our land has been acquired.
That case is that compensation.
Our case is that since compensation was not paid to us, the entire land acquisition proceedings have lapsed. So we are paid for the return of the land.
Lapse under Act 2. Acquisition under Act 2.
Act 1.
1894.
Then how is the question of lapsing? How will it lapse? And what was not published?
Yes. No, published.
Then how did it lapse?
They were supposed to disclose the entire details.
Is it under Act 2?
Lordship, it is under Act 1.
Act 1.
Act 1, 89.
They have disclosed the award, apportionment of compensation. Yes. What is the matter? Tell me, sir.
Lordship, matter is that my land has been acquired. I have paid for.
Where is the notification? Where is the notification?
Yes, kindly come to page number annexure P2, Lordship.
Oh, you are saying. Okay. This is under the new act. This has lapsed, you're saying. Page.
Page 33.
It's 33.
Yes, Lordship.
Page 33 is
Proceedings number 8 of oblique 2003-2004.
Page, which page? Which page?
This is the notice. Thereafter, I prepared an application under RTI. In the reply to the RTI, they have disclosed that Lordship kindly sees page number 37.
Yes, they have disclosed the gazette notification.
Yes, the next page.
Yes. Yes. The notification under section 4. This acquisition was completed. Declaration is 6. Yes, very well. To whom? Where is the award? Where is, show me? Where is? Show me. Where is the award? No. And where have you deposited the money? Under section 31?
Land has been prepared in the alluders, and they have been already disbursed. They are.
Okay. Yes, this was the entire amount. Hey, sir, where is the award? This is the apportionment, award.
This is the award.
This is the apportionment. There is the section 11. This is the proceedings under section 11 for.
No, that is before the commissioner. That is before the, it is not under the National Highway Act.
Under section 11 of Act 1. Where is the award?
Award is under 13 law. Award is published under section 13.
Yeah, under section 11. These are proceedings under section 11. It is a land acquisition act.
The award is published apportionment is given in form 13A.
Form 13A is different. This is apportionment form 13A. Where is the award? Under section 11. This is the apportionment. Where is the award itself? That this has been determined.
Determination. That is not. I will get it. Our cases in this case is that no land of a petition has been acquired. That is the instruction so far. Then it will be department. Already poison has already been handed over to the requiring body. That is the.
So now, Lordship, in that case.
You have submitted previously that the petitioner's land has not been utilized by the requiring body and is lying vacant.
That is not vacant. That was submitted by AD. Land is not lying vacant. We are the acquiring body. We have already handed over poison long back in 2007.
Where is that? Show me the writ of possession. Show me the writ of position. Degi, position, writ of position, degi.
In this case, four plots were acquired.
RS plot number?
RS plot number 47.
What is your RS plot number?
Mine is 6.67 acre comprised in plot number 46, 47, 48 and 51. Are they in recorded in RS Putian number 75?
They are claiming over all the plots. They are claiming over all the plots.
You acquired the same plot?
But our case is that already the land rule act.
You have, if you want, if you say.
They could not, they were served with the notice. They could not produce the parties.
Show me that they have been served with the notice.
Yes, they have annexed to their.
Where is the award? Where is your award, sir? Where is the award? Up to now, apportionment you have shown. Where is the award?
After hearing.
Sir, you have decided something.
We are not right. We have seeking time.
Sir, where is the records? Produce all records.
We will file everything.
No, I will not give you time. Produce records.
We will file everything is ready. Pending affirmation.
Despite direction passed by this court on 19th of March 2021, affidavit in opposition on behalf of the respondents is still not ready. The learned advocate representing the respondents prays for an extension of time to file affidavit in opposition. Full stop. Having regard to the fact that the petitioner's land may have been acquired, having regard to the fact that the petitioner alleges acquisition of petitioner's land without payment of compensation, and since the respondents have not filed their affidavit in opposition, I am of the view that the respondents should be directed to produce the entire records of this case, including the records relating to acquisition proceedings, when the matter is taken up next. List this matter for further consideration on Monday. Monday. Document গুলো ফেরত দিয়ে দিন।
Grateful Lord. Yeah, I pray for Lordship. Mr. Oil Banerjee will be coming. For Lordship, kindly fix us a time. 2 p.m.
Nothing.
Lordship.
I do not know I will be in a position to take up these matters or not.
No, Lordship.
I'm not sure. If you are not interested to the hearing matters, as some of you are doing, I may reach. Otherwise, if people are really interested, how can I reach? Is it possible to reach so many hearing matters? Nobody is interested to do the hearing matters, you see. Yes, call the next matter.
29. That's it, sir, for the respondents.
Who's for the petitioner? Let me dismiss the matter in that case. মানডে রেখে ডিসমিস করি, হ্যাঁ একটাকে করে দিয়েছি, ঠিক হচ্ছে না সেটা, কেউ করবে না। নেক্সট সার্কিট চলছে। None appears on behalf of the petitioner. No accommodation has been sought for. Stop. To provide one last opportunity to petitioner to present its case, let this matter stand adjourned and appear under the same heading on Monday. So it is made clear that if the petitioner remains unrepresented on the adjourned date, the matter shall be dealt with The matter shall be dealt with in the petitioner's absence. No, you are not represented. Yes, call the next matter.
Lordship, in this case, I am for the respondents, Lordship. While if you said day, we are ready for hearing.
Now it is now. The date is now.
No, Lordship. No.
My lord, I am for the petitioner. Actually, in this case, exchange of affidavit has been
All completed.
only hearing in the. Actually, Mr. Jagati Mishra here, he is arguing counsel. Who already, Mr. Jagati Mishra, he is prepared for that. Due to some private reason, he is out of session, but he will come by today evening. It's my humble request before the Lordship
Kindly fix just one declaration, just tomorrow.
Matter is now, today,
Just tomorrow.
what is the matter?
It's SSB or not?
Service matter.
Service matter.
Yes.
Dismiss for service.
Yes, what is the challenge?
Actually,
What is the challenge?
to brief it up.
ये किससे नहीं? Where is the charge sheet?
Lord, actually,
You are not aware.
kindly fix, is my humble request, kindly fix tomorrow, just tomorrow. Then- फिर मंडे के लिए हाँ तो फिर मंडे के लिए I didn't
भैया फिर मंडे
Yes, you see someone else's money. You see someone else's money. 50,000 rupees in Nepali currency and 2900 in Indian currency and threaten them not to inform. You snatched away the money.
It was allegation, my lord.
Yes. That was not proved. Did he prefer an appeal?
Yes, Lord.
What happened to the appellate order?
Second appeal or completed.
Second appeal?
Revision, your lords.
Now you have all started hearing a second appeal.
Lords, in SSB, your lordship, there is a provision
For second appeal?
for revision, your lords.
Revision is not an appeal, sir.
Yes.
Hey, ये देखिए. This is RPF.
No, your lordship.
SSB, my lord.
What is SSB?
सशस्त्र सीमा बल
देखिए देखिए वही देखिए.
सशस्त्र सीमा सुरक्षा.
नहीं. You have the rules.
Lordship, we did not bring the today I am not.
What is rule 162 1A?
162.
1A?
162, maybe your lordship, there is a provision for alternation and other charges, your lordship. Money যদি থাকে তাহলে আছে ঠিক আছে.
Lordship, I don't think it will be here because last time.
Find out from the internet. You are selling a phone. Is it absolutely no without holding an inquiry?
No, your lord.
Inquiry was held.
Yes, Lord. All the procedure has to duly complied, your lordship.
I mean, what all the procedure?
Lordship, I will show your lordship at the time of hearing, your lordship.
Now, I am hearing it now.
Today,
You ought to have been ready, sir. Where is the records of the case?
maybe money. So you can doctor.
Inspector General. Use the sentence of the crime with the punishment related to the more expense.
162, my lord, action by the DIG.
As I go to the annulment. Last motion.
Yes. Very well. When you want this tomorrow?
Yes, sir. What period you have accepted?
Hey.
Day after, tomorrow, today, by your.
These are hearing matters. Same day, all the matters can be taken up. Come tomorrow, come ready tomorrow, bring the records. Friday in the afternoon, you will argue this. Hearing matter.
My lord, one humble prayer, if the matter may be either fixed on tomorrow or Monday, because after the day after tomorrow, Arvind Council will be further, he will be out of station. He will come by today evening, is humble request from our end. Either the matter may be fixed tomorrow or Monday. As your lordship deem fit.
List this matter for further consider. Heard the learned advocates appearing for the respective parties. List this matter for further consideration on Monday. Full stop. Monday next. Full stop. The respondents are directed to produce the entire records of the case when the matter is taken up next.
Deeply obliged.
Hey, what a Passover is it? No.
Lordship,
The learned advocate representing the petition. The petitioner does not want to proceed with the petition. That is your section.
Lordship, Learned Additional Advocate General is personally involved in this matter, and right now he cannot proceed until.
You are for?
I'm for the petitioners.
Then how are you interested in what happens with the respondents?
I'm the junior.
My lord, I'm referring for the respondent number 2 and 5. 2 to 5, my lord.
In item number 27, I appear for the respondent in and all corporation, my lord.
Upon instruction, my lord.
Bring written instruction to. Instruction tomorrow, not today. এটা মাথায় দিয়ে দেবে 1 নম্বর করে দেবে being written instruction তাহলে ওই থাক ও তো উঠে আসবে এমনি নরমাল উঠে আসবে 27 হ্যাঁ yes written instructions tomorrow
Grateful, man.
Milord, I appeal for the respondent numbers 2 to 5 in this matter.
Petitioner. Yes, it was tender matter.
Down. The learned advocate representing the petitioner. The petitioner submits that the present writ application, having become infructuous, he has instructions not to proceed with the same. So in view thereof, let this matter stand dismissed as withdrawn. Says in view thereof, let this matter stands dismissed as having become infructuous.
The work has been executed. I have challenged in the tender.
The work order has already been issued. Has already been and at least for the petitioner, no accommodation has been sought for. In view thereof, to provide one more opportunity to the petitioner, let this matter stand adjourned and appear before the next available circuit. Before the next level, sir. My lord, no, today.
I'm for the petitioner.
Yes, madam.
I'm for the petitioner, please, appearing on behalf of Arindam Das, praying for not to delay. Hello.
What is the matter?
With regards to a petrol pump.
Before. Sir, you are appearing for?
Actually, we are from petitioner, my lord.
Who is she appearing for? Who is she appearing for? Sir, you want a regular circuit. You are not ready.
My lord, actually this.
Instructed
My lord,
I'm not on that. I'm saying that you want a regular circuit. That is your demand.
Obviously, my lord.
But you are not ready. Had it been a principal bench, this would have been dismissed by now.
My lord, it's very unfortunate, but in his it's emergency requiring, he left just yesterday, and he will come by today evening. Tomorrow, all the matters, humble prayer before lordship.
Is it possible for a court to take up all the matters in a particular day when the learned advocate is there? Try and understand and tell me. Will each matter, consideration of each matter not take time? If you start playing this in this manner, then nothing will happen. If you see, if you want all these matters to be taken up on one day, it is not possible. All will be taken up, and these matters will be adjourned. It is entirely dependent upon the bar how the court will proceed.
Absolutely, my lord.
Because without your cooperation, the court cannot dispose of the matters.
Absolutely, lordship. Actually, we tend
You are a very important stakeholder.
Yes.
Are you not?
Obviously.
Then?
Obviously. No, we tender apology, my lord, but it's
not
actually
this way. On the prayer of the learned advocate representing the petitioner, let this matter stand adjourned and appear under the same heading Monday next.
My lord, for item number 35 and 36 will be the same prayer from.
Same Monday next.
Deeply obliged, my lord.
See, in your absence, I cannot dispose of matters.
Appearing for the petitioner, lordship. We are very fortunate, my lord.
No, not that. If you are not interested, the only thing that if you are interested, then only matters can be disposed of. Otherwise, it will go in a circle loop. Every circuit will get adjourned.
Actually, it doesn't happen, my lord. It's very essential emergency.
No, 38.
Deeply
37 হয়ে গেল তো।
No, my lord, 34, 35 and 36.
Lordship.
Lordship, Mr. Navakumar Das is appearing on behalf of the petitioner. Lordship, he is sick, kindly fix on Monday. He will be here.
On the learned advocate representing the petitioner, let this matter stand adjourned. Monday. Monday next.
My lord, 6 I'm appearing for the petitioner, lordship.
Appear on next Monday. Monday next উল্টো শুনবে।
My lord, 36 I'm appearing for the petitioner, lordship.
At your instance, the matter was adjourned.
The 36 I'm appearing, I'm ready with the matter. If Mr. Mishra is assisting me in this matter, I have no qualm to appear on Monday.
Matter was adjourned at your instance. Your advocate on record was there in court. He an adjournment.
Very well, lordship. I will come back on Monday because on Monday your lordship has already fixed the 16-4 matters.
Lordship, sir, for the respondent.
38 also same. One behalf of Mr. Navakumar Das.
Monday. Oh, you order it, yeah. Thirty-nine.
39 Malor only making application. Mr. Sanjeev Das is appearing, Malor. But
not today.
Lordship, sir, for the respondents, lordship.
40.
Dates arguing in this case, lordship.
Yes. Lordship, Mr. Omreshra is appearing for the petitioner. Actually, I am only praying for not today.
Lordship, tomorrow will lordship finally not fixed. And not well in lordship for doing this matter.
Now, this matter was taken up by Justice Amrita Sinha. Our petitioners had finished the argument. It was their turn, but the circuit got.
Yes, lordship. When period of time is lordship, on that time the matter is kept pending.
Monday, not this week.
Lordship.
On the prayer of the learned advocate representing the respondents, this matter stand adjourned and appear. লেখো লেখো তুমি লেখো অর্ডারটা ছাপো। On the prayer of the learned advocate representing the respondents, that this matter stand adjourned and appear under the same heading on Monday. আর ব্র্যাকেটে ডেট দেবে।
দিচ্ছি।
সার্কিটে অমৃতা শিলার ঘরে আমরা রেডি ছিলাম, আমরা রেডি ছিলাম।
আমি তোমাদেরকে বলেছি তোমরা ছিল না, বাট ওদের
শেষ করতে
আমি বলেছি যে আমাদের হয়েছিল, ওদের বলার টাইম হয়েছিল কিন্তু সঠিক কথা।